Okay, so let's go on the record on, we're going on YouTube, and it's James Mozzie versus Indemnity Insurance Company of North America, DC 193295. Counsel, if you guys want to go ahead and introduce.
Yes, Your Honor. Randy Johnson here on behalf of the plaintiff, James Mozzie.
Good morning, Judge. Brandy Prejean here on behalf of the defendant, Indemnity Insurance Company.
Something happened. I got knocked off. Can you guys hear me okay?
I can hear you now. I couldn't hear you there for a minute.
All right. I think we're on YouTube now, so let's get started with the summary judgment.
Judge, thank you. It was originally our motion for summary judgment on this issue. This is a judicial review and workers' compensation claim. And our motion was filed really on a procedural issue. The plaintiff in this case is asking for the workers' compensation determination by the Division of Workers' Compensation to be overturned on all points. And in order for judicial review to be sought on a case in a workers' compensation claim, there's two different hoops, if you will, that have to be jumped through, one of which is the original petition must be served on the Division of Workers' Compensation simultaneously with the defendant, or when the suit is filed. And the reason for this, Judge, is because the Division of Workers' Compensation wants to be made aware of any lawsuits filed where the plaintiff is seeking to overturn their findings because they have a right to intervene in that lawsuit and protect their interests.
According to Mr. Johnson's briefing, though, isn't there a Supreme Court case on point that's, at least according to him, I haven't read the case, that says that this is not jurisdictional and not grounds for a dismissal?
There is a Supreme Court case that talks about this case, talks about the simultaneous filing not being a jurisdictional issue. In that case, that was a plea to the jurisdiction, where it was saying that the court didn't have subject matter jurisdiction. Our argument in this case, Judge, is that the findings of the division became final because it was not simultaneously served on the division and they didn't have an opportunity to intervene in the lawsuit. That's the purpose of it being filed. The court in that case really didn't get into the discussion of whether or not there would be legal consequences, regardless of jurisdictional questions, for that failure to simultaneously file.
Are there any Supreme Court decisions that says that support your position?
There have not been any since that particular case. It's just indicative that they said that they were not going to comment on whether or not there were legal consequences that would result because that wasn't raised in the appeal.
Are there any cases out of the Dallas Court of Appeals that require me to dismiss in the situation?
Not that would require you to dismiss, not that are still good law, no, sir. They were expressly overturned by that case.
Okay. Did you have anything else?
Yes, I do, Judge. The second argument in this case was that the defendant was not served timely. The defendant was not served until 5 months after the suit was filed, which they did not, if the division wasn't made aware that the suit was filed and the defendant wasn't made aware that the suit was filed. And in between the filing of the lawsuit and the serving of the defendant, the plaintiff had surgery that was a major issue in this particular case that would have been important for the insurance company to be made aware of that they'd been sued. Just to give kind of a little bit of a purpose, Judge, on why it's important for these workers' compensation insurance companies to know that they've been sued on a case such as this, where there's an issue of maximum medical improvement, impairment rating, and I'm not going to get into the merits of the case so much, but those are issues that are important to be final because it affects the reserves that are kept on the insurance claims, the budgets that are made on these outstanding insurance claims. There's a need for these insurance companies to know whether or not the division's findings are final or not, so they can move on with budgeting for the rest of the high volume claims accordingly. So there's actions being taken by the plaintiff between the date of suit and the date of service that affect the financial reserves on this case, but the defendant wasn't even aware of the lawsuit until after the court informed them that the case was going to be dismissed.
Okay, anything else?
No, that's it, Your Honor. Thank you.
Response?
Good morning, Judge. I fully appreciate that Ms. Prejean wasn't involved in this at the start and is filling in, but the summary judgment evidence is absolutely indisputed, uncontestable that the DWC, the Division of Workers' Compensation, was made aware of this lawsuit and did not choose to intervene. The reason that they are supposed to be made aware is so they can intervene. And our summary judgment evidence establishes that the division was served with this petition on March 11, 2019, just 5 days after it was filed. And that's Exhibit 5, which is an excerpt from the certified DWC file that we obtained and shows a copy of the petition was file stamped received on March 11th, the Monday following the day that it was filed. That complies with the simultaneous filing requirement. In addition, as you pointed out, there is case law that says it is not mandatory or it's not jurisdictional and it does not require dismissal. At most, what would have been required had we not had Mr. Mozzie, who was pro se at the time, had he not served it on the division, you would have been required to abate it until they got served and had their opportunity to decide whether or not to intervene. But their first round of error, not to put too fine a point on it, the contention that they were not made aware is just simply not true. It was filed with the division on March 11th, just 5 days after it was filed in court. And of course, you're required to send it to them through the mail. That's how it's done. It takes a little while to get there. In this case, I think that's surprisingly fast to get there on Monday after it was filed. So that's number one. Number two, the issue about surgery is completely irrelevant to what's going on in this lawsuit. The reason for that is that there were three issues presented to the administrative law judge. One was an extent of injury issue. That extent of injury issue had two disputed injuries. One was a rotator cuff tear. The other was a cervical nerve root traction injury. The administrative law judge in this case found that the rotator cuff tear was part of the compensable injury, but found against Mr. Mozzie on the cervical nerve root. So the only thing that was appealed in this lawsuit was the cervical nerve root traction, the neck, nothing to do with the surgery. The surgery was for the shoulder. More importantly, because no one appealed the finding that the rotator cuff tear is part of the compensable injury, that became final as a matter of law back before this petition was ever filed. Well, at the time of the filing of the petition, because at that point, no one had filed it. And prior to this surgery that was done. And so we provided you evidence, which goes to our motion for summary judgment, and I'll reserve discussion of that for that part of it, but we provided you evidence that this was a pre-authorized surgery based on the fact that this was something already determined to be part of the compensable injury. It would have made no difference to this, Terry. There's nothing, just the fact of this filing of this lawsuit would have been irrelevant to whether that surgery was done or not done, because it was for the rotator cuff tear for which there was a final at that time finding of that is included in the compensable injury. So as far as our summary judgment evidence with regard to their two issues, it is the summary judgment evidence conclusively establishes that the division was served with the petition simultaneously, that Mr. Mozzie exhausted his administrative remedies and timely filed his suit in this court of competent jurisdiction, all of which they've admitted in the admissions, which is part of our exhibits, that he believed when he filed his petition. And if you look at the petition, the way it's set up in the petition, it provides initially in the petition a request. He includes a request for service of the carrier. in the body of his petition through their registered agent at the address that's given in the decision and order that's appealed, which is standard procedure. And then he also includes another paragraph that says, and I am serving the division with this. His understanding as a pro se plaintiff was that by requesting that in his petition, that the court or the clerk would issue the citation and service and have the division or have the carrier served, and that it was his responsibility to serve the division, which he did. He didn't know otherwise until August. And as soon as he found out, he requested a citation. He got the carrier served, which, by the way, their motion says they weren't served until September 27th, but it's clear they were served on August 27th. And he did so diligently. And so we provided an affidavit on that, explaining that he acted diligent. And their response to our response, their reply to our response, does not present any evidence to the contrary. There's nothing to rebut that he acted diligently. And so for those reasons, we're asking that you deny the carrier's summary judgment as to both issues.
Summary judgment is denied. Let me ask real quick, Mr. Chu, did you guys settle or no?
No, Your Honor, we did not.
Okay. Well, once we're done with the summary judgment, we'll start y'all's trial.
Thank you, Your Honor.
Okay, go ahead on the counter motion for summary judgment.
Yes, Judge, thank you. The counter motion has to do with the other two issues besides the extent of injury were, did he reach maximum medical improvement, and if so, on what day? And in this case, what happened is after the first administrative law judge determined that the extent of injury included the rotator cuff tear, she ordered a designated doctor examination. And that designated doctor examination was performed while this administrative proceeding was pending. The designated doctor came back and said, well, I've looked at this. I'm finding he reached maximum medical improvement on October 2, 2017. Mind you, that's just a short 12 days after this injury, an injury which the carrier has accepted and stipulated includes at least a sprained shoulder. So we have a designated doctor who looks at it, disregards the recommendation of surgery that had already been made, and says, hey, he was as good as he's ever going to get on October 2, 2017, just a couple of weeks after he got hurt. Now, we've appealed that certification, and that's the only certification that can be considered in this case. So if it goes to the jury, the question is going to be, do you find that he did not reach maximum medical improvement on October 2, 2017 as certified by Dr. whoever, whatever the designated doctor's name is. The important thing to keep in mind here with regard to maximum medical improvement is you cannot, is that we provided you appeals panel decisions 072232 and 110896, which are in our exhibit 19, which clearly stand for the proposition that when you have someone, as we have in this case, where they undergo surgery that's pre-authorized by a carrier, and that pre-authorization occurs subsequent to the maximum medical improvement date, and the surgery occurs subsequent to the maximum medical improvement date, it is self-evident that the injured worker was not at maximum medical improvement because there was still something out there, something that was recommended that might cause material improvement or lasting improvement. And so in this case, what the summary judgment evidence shows with regard to this is that, number one, Mr. Mozzie's injury includes a right shoulder rotator cuff tear. That's cannot be disputed at this point because that's an unappealed finding. That he was recommended surgery before the decision and order was entered in this case and before the designated doctor's evaluation on September 20, 2018. For example, you can look at plaintiff's exhibit 16, which shows that there was a recommendation of surgery before, and I believe 13, wherein Dr. Levy on March 23, 2018, long before the designated doctor's examination, but after the MMI date found by the designated doctor, said he's not reached maximum medical improvement. He may eventually require surgery on it. An MRI is pending. That's exhibit 13. Exhibit 14 is the MRI that he underwent on May 3, 2018. Exhibit 15, Dr. Levy comes back, reviews the MRI, concludes that he's failed conservative care and likely needs surgery. Then on 10/24/18, again, Dr. Levy confirmed he failed conservative therapy, recommended surgery, and indicated he would start the process of requesting surgery. That's Exhibit 16. He did do that. And then on March 29, 2019, the carrier servicing provider, their utilization review company, certified that the right shoulder surgery was medically necessary. That's plaintiff's Exhibit 17. And then the surgery was performed on May 1st of 2019 and was a shoulder surgery. That's plaintiff's Exhibit 18. And then finally, we have Dr. Pearson, who's come along after the fact, found that he was not at maximum medical improvement until a much later date. And he even says in his report that per division rules, if you've got someone who has surgery after a maximum medical improvement date, and it's for a compensable body part, then it's self-evident that they could not have been at maximum medical improvement on an earlier date. And so what you have here now is the carriers come back and they've responded. They haven't provided any summary judgment evidence to dispute any of those facts that I've just recited to you, none of them. What they've said is we object to Exhibits 12, 17, and 18 because these you can't have evidence of impairment rating without a substantial change of condition. And yes, there is a statute that says when we get to judicial review, and this is really the only restriction in a judicial review case on the scope of the evidence, is if you are talking about impairment ratings, you cannot have evidence regarding the impairment rating that wasn't presented to the division. But the case law is crystal clear, despite the carrier's suggestion to the contrary in their response. The case law is crystal clear that that prohibition only goes to evidence which goes to the impairment rating. MMI, maximum medical improvement, is a separate issue from impairment rating, and you can have new evidence at the division of regarding the maximum medical improvement date. And so their objections should be overruled. They're not well taken. They are allowable. And so I'm sorry, I just sent this to the court yesterday, some case law on this issue, including the Weeks case, or I'm sorry, the Hill case, which is out of the Dallas Court of Appeals. Find that citation. It's 194 Southwest 3rd, 162, Dallas, 2006, petition denied. And in that case, there was an argument about what the scope of the evidence was. And there was an argument that the evidence on extent of impairment should be limited to that presented at the division. What they're doing here.
Let me hear from opposing side. Opposing side.
Thank you.
Thank you, Judge. I think that it's a little, we're kind of going down the rabbit hole a little too quickly in discussing whether or not the evidence being submitted to support the issue of whether or not this individual is at maximum medical improvement stands for the proposition that it is new evidence of extent of impairment or not, because the question really is, as a matter of law, is this individual at maximum medical improvement, and are there no fact questions in that regard? And our argument and our response and our position today is that there are numerous fact questions. That's why we're here. Whether I have to prove that he was at maximum medical improvement on the day that the judge found that he was at the division level, and Mr. Johnson has to prove that he wasn't. And there's a whole bunch of questions that have to be answered before we decide who's right on that issue. The first thing is whether or not the surgery that was being discussed early on in this case, that eventually occurred later on in the case, was a surgery that was indeed to treat the compensable injury in this case and not for other conditions.
Didn't your client though pre-authorize the surgery?
They did pre-authorize the surgery, Your Honor, but from a legal standpoint, whether or not something is reasonable and necessary for a particular condition does not equate that the treatment is for a compensable injury. If a claimant submits a pre-authorization request and to utilization review for cancer treatment, and they have cancer, that treatment's going to be approved because it's reasonably necessary to treat that condition. That does not equate that the insurance company is saying, and that condition is also a compensable injury. And in this particular case, and I really don't want to get into the weeds.
I guess I'm not, you guys are more into the weeds on this workers' comp stuff. We don't see a whole lot of this anymore.
Right.
So you're saying that if somebody has cancer that is not related to their work, like that, let's say they have lung cancer from smoking their whole life, and then they submit it to pre-authorization through workers' comp, the carrier automatically has to approve it if they have cancer, even if it's not related to a workplace injury?
That's right. Well, they don't have to automatically approve it. Their analysis is only whether or not that treatment request made by that provider is reasonable and necessary treatment for the conditions that are diagnosed in the paperwork that's submitted through the utilization review company. The utilization review company has no idea what the compensable injuries are or what the specific injuries. I mean, their issue is just to review it from a medical standpoint, not from a liability standpoint. It's up to the insurance company to inform the pre-authorization company what's been accepted, what's not been accepted, what's been adjudicated as compensable or not. The issue of whether or not this treatment was reasonable and necessary medical treatment does not equate that it was treatment for the compensable injury. Does not equate that it was treatment for the rotator cuff tear. And you can look at the operative report in this case and see very clearly that it was not treatment for the rotator cuff tear. That there were other conditions that the treatment was dealing with. So it's disingenuous to say it's just so simple that the treatment was for the rotator cuff tear that's been found compensable, because that's not accurate.
That seems okay. Anyway, go ahead, Mr. Johnson.
2 quick points. We don't have to prove that he did not reach MMI before the contested case hearing. We only have to show that he did not reach MMI on the date certified by the division, which was December or October 2, 2017. And clearly we've met that burden of proof. This is our summary judgment. We need to keep this in context here, because the carrier has presented no summary judgment evidence to support the contention that this surgery was not for a compensable body part. Your Honor, Exhibit 17, they approved this surgery for the right shoulder debridement, arthroscopic subacromial decompression, arthroscopic synovectomy. In other words, they approved it he was recommending surgery for the rotator cuff. They approved surgery for the rotator cuff as being reasonable and necessary. The rotator cuff has been found as a matter of law to be part of the compensable injury. A plus B equals C. The surgery was for the rotator cuff. The rotator cuff is compensable. The surgery was for a compensable injury. And you need to only look at PEX or plaintiff's 18, the operative report. It's for preoperative diagnoses, impingement syndrome with possible partial thickness rotator cuff tear. They did a rotator cuff repair surgery. That's what was pre-authorized. The rotator cuff is compensable. The appeals panel decisions make clear that when that happens, if there's an MMI date that predates that, it is invalid and should be set aside. And that's what should be done in this case. And then it will go back to the division under Samudio. And I believe that may also be referenced in the pattern jury charges, by the way. I don't know that they talk about the remand, but I've cited the Samudio case, which supports that. So this is very
How do you spell Samudio for the court? Or we don't have a court reporter. Never mind. Don't worry about it.
Okay, and it's one of the cases that I've cited. I also sent you a highlighted copy of that into counsel. Bottom line is, on our summary judgment, we've provided the summary judgment evidence that proves that he had surgery, which was for a compensable body part, the rotator cuff tear, which was pre-authorized. All of that happened on a date after the MMI date that was certified by the division. One other key point, Judge, is that I think we could explain what the hearing officer did. The hearing officer has to give presumptive weight to the designated doctor, and they did that. And this was a different hearing officer than heard the original part of it, but it's absolutely crystal clear that the presumptive weight rule does not apply in this proceeding, and that's pattern jury charge 15.3 speaks to that. And the Garcia case, which found the compact compensable, said does not get presumptive weight here. So now we're just looking at, is that the correct MMI date? The evidence conclusively demonstrates it's not the correct MMI date. Therefore, his certification of MMI is invalid. And if his certification is invalid of MMI, then thereto his impairment rating is invalid as a matter of law. So we should be granted summary judgment on those issues, Your Honor. Thank you.
Well, I mean, we're making a lot of assumptions. First, the comment was that the designated doctor disregarded that there was possibly surgery that was going to be recommended. And I believe that Dr. Levy's wording was May after he looked at the MRI. I mean, that's a fact question, whether or not the DD in fact disregarded that recommendation, whether or not the DD believed that was going to be treatment for the compensable injury. Whether or not the designated doctor's opinion has presumptive weight is not really the issue. It's the issue of whether or not the designated doctor's reliance upon the evidence at that time should now be found invalid. I mean, that's really the argument from Samudio, is that you don't have a valid certification before you. And whether or not that designated doctor certification was valid based on whether or not there was a complete disregard by the designated doctor for the evidence at that time, whether or not the AMA guides, which I don't really want to get down that rabbit hole, were correctly applied in this case. I mean, there's a lot of questions of whether or not this individual was at maximum medical improvement. It's a very intense fact question.
What fact issue did you raise to challenge to create a genuine issue of material fact in this case?
Well, the primary one would be whether or not the surgery was for the compensable injury, because that's the first hoop that has to be jumped through.
But what evidence did you show that it wasn't?
Well, the operative report that's in evidence that was submitted by the plaintiff shows that the first diagnosis code is an impingement syndrome, which is not a compensable injury in this case.
Mr. Johnson, respond to that.
Judge, that's an incomplete reading of this. It says preoperative diagnosis, right shoulder impingement syndrome with possible partial thickness rotator cuff tear. He performed a rotator cuff tear repair. The rotator cuff was found to be part of the compensable injury. And by the way, it makes no difference what the designated doctor did or didn't disregard. The question is, did these things occur after the MMI date he found? You don't even have to look at how he got there or why he got there. All you look at is that MMI date, does it predate the authorization of the surgery and the surgery that was performed? And it clearly does, and they have not raised a fact issue on that.
Okay. I'm going to go ahead and grant summary judgment on this as well. I'll grant summary judgment on this. And then, so I guess the result is if I grant summary judgment, it gets remanded back to the Work Comp Commission. Is that how this works?
Judge, we prepared an order which at this point it would be a partial judgment because we still have that other extent of injury issue, but based on your ruling, we might drop that and then it could be a final judgment and it would go back to the division. But as we have to do with workers' comp, however we phrase that judgment, whether it's partial or final, that has to be sent to the division for them to percolate for 30 days before you can sign it. So the order basically says that I proposed says you're granting the motion for summary judgment. You're ordering us to prepare that judgment to submit to the division, which would be the proper procedure, I believe.
Okay, I'm confused because you said it's not final unless you decide to drop this other point, right? And you haven't decided to drop the other point yet. We're 99% certain we're going to do that. I just, based on your decision, I need to confer with my client and co-counsel, but we would probably. Well, why don't you do this? Why don't you, I don't know if I want to sign the current order, then go ahead and prepare an omnibus order that covers all the rulings in this case, as well as whatever you decide to do on this last issue. go ahead and share it with Ms. Prejean, and then go ahead and make sure it says that this was heard on August 6, 2021, instead of on this date, and then send that to Rhonda and e-file the new order.
Will do it, Judge. Thank you.
Thank you, guys. Have a good day.
You too. Thank you.
Okay, so I guess we have a trial on this case. Mr. Chu, Mr. Newton,
Yes, Your Honor, we do.
Yes, Your Honor.
and part of the case is settled, I guess.
Yes.
Tony, are you there? Tony?
Yes, I am, Judge. Sorry.
Okay. All right, Mr. Newton, go ahead and announce the cause number and case name of the trial we're about to start.
Yes, Your Honor. The cause number is DC 19-16514. It's Corey Anderson as plaintiff and A Better Place LLC intervener versus Linda Marquez, defendant and counter plaintiff, and Kenneth Bench, the third party defendant.
Okay.
And I believe, Your Honor, we also have a motion for leave to admit the an answer filed by the plaintiff and counter defendant.
Okay.
For the defendant, Linda Bench, we've filed a request the court restyle the case, but her name is Linda Bench, not Linda Marquis. She's the defendant counter plaintiff against Corey Anderson.
Okay.
That's who we represent.
Who represents the third party defendant?
He has not been served.
Okay. All right, so what exactly, there's been a settlement, I guess, of the intervener's case, and then some people haven't been served. What exactly are we trying today?
Yeah, we're trying. Their original claim for Corey Anderson was a suit for partition. They sought no other. They sought no other relief. They transferred that interest to the intervener, so I don't believe they have any standing at this point to go forward with a request for partition. So I believe the only matter before this court is the counterclaim for the assault, civil conspiracy, and I don't think we need a deck action at this point. So we like to present our case for the assault.
So is that right, Mr. Newton? You no longer have any affirmative claims?
It is correct, Your Honor. We no longer have any affirmative claims because when my client sold his interest in the property, it essentially removed all of his interest in the property, and thus we would have no further right to partition.
All right, so I guess if we're going to restyle this, it would be Linda Bench versus Corey Anderson are the only claims that are left, and it's for civil assault and conspiracy. Is that what you said?
That's correct, Your Honor.
Right.
With that being, Your Honor, just going back to the fact that Mr. Bench has not been served in this case, and he is one of the, well, he was the only other party within the civil conspiracy realm. So he's kind of a necessary party to this suit if you're going to claim any sort of conspiracy.
Yeah. May I respond? Do you need a response, Your Honor?
Yes.
Okay. You don't have to sue all the parties to a conspiracy. You just have to prove that they were acting in a conspiracy, aiding and abetting, etc. This is an assault matter.
I'm not sure I'm following you, I guess.
Well, to prove up a conspiracy, you don't have to sue all the conspirators. The evidence just has to show that they were acting in concert or they were aiding and abetting the offense, in this case, the assault.
Your Honor, in this particular matter, that's a slightly disingenuous statement because they actually did sue Mr. Bench. They just refused to serve him.
So the argument is that this gentleman was in a conspiracy with Mr. Anderson to commit assault on Miss Bench. Is that the idea?
Correct, Your Honor. They were attempting to extort from her signature to transfer the property to any interest she had to Corey Anderson. That's what the evidence will show.
I guess I've never seen a civil conspiracy claim where you didn't have the conspirators there. Well, I'm not sure what the point of this would be. We can't hold the third party defendant responsible if he's not been served.
We're not
right?
we're not requesting that he be held responsible. Yeah, the situation is the information as to Kenneth Ray Bench is in the possession of the defendant under the restyle Corey Anderson. In our answer to the original claim, we requested disclosures, which they never responded to. And so that becomes a problem for Corey Anderson.
All right, so let's just cross that bridge when we get there, I guess. So, I am going to restyle this case so that it's Linda Bench versus Corey Anderson. I'm going to allow you to try the civil assault case. I don't see how you can try I don't see the point of trying a conspiracy case when you don't have any other conspirators in the case. The conspiracy would I assume, try to get whoever the conspirator is to be responsible as well for the assault. But if they're not in the case, I can't hold them responsible. So we're just going to try the Linda Bench versus Corey Anderson assault case. So, Mr.
Yes,
Chu, you may proceed with, do you want to pre-admit any exhibits?
Well, Your Honor, we still have the motion for leave as well on the filed answer, which
And what
also
is-
held a statutory claim or an affirmative defense for limitations because the assault took place 4 years prior to, or the alleged assault occurred 4 years prior to, or more than 4 years prior to the filing of the counterclaim, which is outside of the statute of limitations for assault, which is 2 years.
may we respond, Your Honor?
Yes.
Yeah, I'd like to go ahead and pull up the e-filing records showing that Mr. Newsom had never opened up the counterclaim until, I believe, last week, unless counsel concedes that. I'll pull that document up for the court's reference. And this is in response to his move for leave.
Let me ask this first off. So there's, when was this case originally filed? When was the lawsuit filed? What day? I can look it up if I need to.
It would have been sometime around September of 2019, Your Honor.
Okay. And when did the assault occur?
It occurred August of 2017.
And what is, okay, and so what?
So still more than 2 years, Your Honor.
And it's, my recollection is fortunately I don't have all my books here. The statute of limitations for assault is 2 years, isn't it?
Yes, Your Honor.
That's correct, Your Honor.
Okay. This is what I'm going to do. I'm going to go ahead and grant leave to file the answer in this case. But Mr. Chu, I guess the question is, I want to be fair to you. Since I'm just granting this now, do you still want to try this case today, or is there something else, any of the discovery you would do?
Well, Your Honor, let me bring this point up. They appeared for a DWOP hearing once before, Your Honor, here. That would be Mr. Newsom and my client, Linda Bench. They had not obtained service. There's no so-called return of citation in this case. We filed a voluntary answer to their claim, Your Honor, and within 30 days, we filed our counterclaim. So I believe the law permits us to go ahead and proceed on a counterclaim. If the court needs briefing on that, we'd be happy to supply that, but we would like this case called.
So I guess my question is, okay, so this gets a little complicated. So There is the relation back doctrine. I'm familiar with that, you know, if you add additional claims, they can relate back to the original filing. But I don't know how you file a counterclaim that's past the statute of limitations when the original suit, that gets kind of interesting there.
Yeah,
Yes,
I've
Your
had
Honor,
this
they
happen
didn't add
before.
any claims. That was their
Your Honor.
original claim, was in September. Their original claim was the counterclaim.
I think you're misunderstanding what I'm getting at. So there's a relation back doctrine, right? So if you file a suit within the statute of limitations and you add additional claims, they usually relate back to the original filing of the suit. That's generally the law, I believe. And so in this case, as I understand it, the case was actually filed on 10/10/2019. The original lawsuit was for partition, correct, Mr. Newton?
Yes, Your Honor.
And I assume that there wasn't a statute of limitations issue as to the partition claim, correct?
Correct, Your Honor.
Okay, so the question in my mind is, so Mr. Chu is saying he can file a counterclaim because I'm not sure what his basis is exactly, but even if you said, okay, the filing of the counterclaim would relate back to the original filing of the suit, which was on October 10th, it would still be past the statute of limitations, is my understanding. And so
that is correct, Your Honor.
the question I have is there some other doctrine that I'm not aware of off the top of my head that would allow him to file a counterclaim that is barred by limitations, even if it relates back to the original filing? Because usually you're not going to have this issue come up because the original filing will be within the statute of limitations for all claims. But because there's different statute of limitations for partition claims versus assault, am I making sense here? You guys kind of follow?
Yeah, sure. You're making sense. If I may help the court here. Under CPRC 16.09, if there are any claims between the parties, no matter how long they may have been in terms of time, as long as you file it within 30 days of the answer date, then those claims are revived past the statute of limitations. Again, we'd be happy to brief that for the court if necessary.
16.069, Mr. Chu. Sorry for interrupting, Your Honor, just in case you were going to go find that statute. It's Civil Practice and Remedies Code 16.069. This is William Nisley speaking. Sorry, I can't get my video working. My phone's resisting my ability to turn it on.
Okay. Let me look this up. Okay, so your argument is that the assault that rises out of the same transaction or occurrence that the partition did?
Correct.
Okay.
Your Honor, this was a partition case. It does not arise out of a partition is a kind of a unique and separate action under the law. It's simply a claim to force the sale of a property of which has multiple owners. An assault is not out of the same transaction or occurrence of events.
Yeah,
Except, Your Honor, we would argue that the basis of the assault was to force Linda to transfer her ownership interest in the very same property that this partition case is about. So therefore, when the assault was unsuccessful and she refused to sign, they then moved for a partition. So we would argue they're based on the same transaction and occurrence.
Your Honor, first of all, we highly reject the notion that there was an assault or that anything similar occurred. Second of all, I would say that the partition, the facts that arose that gave rise to a partition just relate back to the fact that my client, Mr. Anderson, obtained an interest in the property. It was not from Miss Bench, though. It was from Mr. Bench, Kenneth Bench, and then also a Nancy Swindell. So that's the vents rising to the partition have nothing to do with Mrs. Bench. They have everything to do with the fact that Mr. Anderson obtained an interest from Kenneth Bench.
You know, not to get into the case, but evidence is going to show that Kenneth Bench stole a will that transferred the property to the children of Linda Bench. So, but again, I don't want to get into the facts here, but it doesn't limit us in that particular statute to transactions. I've had a case where in a divorce, they brought back a assault on a third party witness of 20 years ago. And so it's a statute that allows the parties to bring claims between the parties.
I mean, looking at 161069, I think Mr. Chu is probably right, but I guess the question will be, is part of the same transaction or occurrence? You know, I think we should just go ahead and go forward with the assault claim now. We'll just kind of figure this out. I'll let you guys do post-trial briefing if you need to on the statute of limitations issue. All right, so let's pre-admit any exhibits. Do you have any exhibits you'd like to pre-admit, Mr. Chu?
No, not just yet, Your Honor. Is my client in yet? I don't see her.
What's her name, Sam?
Linda Bench. And I don't see.
Is that her? I think she's there.
Linda, are you there? Are you muted?
If you're listed as Sam, then you're muted, ma'am.
Your Honor, I'm here with the clients. It's really nice.
Okay, and can you unmute again so that we can hear you?
I just said, Your Honor, this is I'm where Linda Bench is at, and it's not with me, but I was just.
I can't hear you. I'm so sorry. Ma'am, could you please speak?
Yes.
Wow, okay, so there's some kind of feedback, I think. Okay.
Yes, I'm here, Linda Bench.
Okay, we can hear you. We can hear you. Okay. So, Mr. Newton, do you have any exhibits you'd like to pre-admit?
No, Your Honor. I'll admit them as we move forward.
All right, let's start with opening statements.
Yeah, Ms. Bench, who is the daughter of Joe Bench and Jesse Bench, has lived in this house since she was born. She took care of, the evidence will show that she took care of both her parents, Jesse Bench, who died in that house, and that Miss Bench has lived there with her children since birth. The evidence will show that in August of 2017, Kenneth Bench, her older sibling, drove up in a red Mustang, followed by a Ford black pickup truck with heavily tinted windows, driven by Mr. Corey Anderson, appeared on a Saturday, and they both got out of their vehicles, as will show, approached the house. She was standing outside. They approached her. She was frightened. The evidence will show that there's been a history of domestic abuse by Mr. Bench. The evidence will show that she had to call the police on him when she was in high school. So the evidence will show she was extremely frightened in that situation. They approached Corey Anderson. The evidence will show was holding a clipboard, and the two were demanding that she sign over any interest she had in the property to Mr. Anderson. She refused. The evidence will show that they moved towards her, and the evidence will show that Kenneth Bench hit her in the chest, knocking her down. The evidence will show that she attempted to get up, get back in the house, and Corey Anderson grabbed her. The evidence will show that a witness, Alphonse call the police. The evidence will show that her son Oliver, with her daughter inside, had witnessed on camera what was going on, and a friend had to be called along with the police to try to stop the assault. And so she did not sign, and she suffered physical injuries. She had to take medication. She did not see a doctor. She suffered anxiety and mental anguish and pain and suffering. And this will show that Mr. Anderson and Mr. Kenneth Bench, both have a history of drug use, and that the evidence will show that they acted with malice in their attempts to assault her and extort a document from her, Your Honor.
Okay. Mr. Newton?
Yes, Your Honor. Beyond the fact that Mr. Anderson obtained an interest in this house and started partition, probably the most important fact in this case is actually a statute, which is section 256.003 of the Texas Estate Code. And it provides that
What's the section 256 what?
0.003 of the Estate Code,
Okay.
which states that a will may not be filed of record, or a will may not be probated within 4 years unless the applicant, who's the applicant for probate, was not in default for failing to start the probate process. And that's in Part A. And Part C states that even if a will is probated after the 4-year statute of limitations, any purchaser for value in good faith has good title against those, has good title against any other heirs. And the reason why I'm saying that is that the facts in this petition, or the facts in the counterclaim, are drafted as such to make a better place, who is the eventual owner of the property, seem to have a conspiracy with Mr. Bench and Mr. Anderson for the purposes of filing in the probate court and obtaining an interest in the property and preventing the partition. And I think the facts will show that the petition was drafted very carefully to stay within those rules. The alleged incident happened 4 years prior to the counterclaim. Mr. Anderson was never present with Mr. Bench and Linda together. The evidence will show that. The evidence will show that Mrs. Bench never alleges that the plaintiff actually struck her. There's no evidence or pleadings or responsive documents to state that Mr. Anderson physically threatened Mrs. Bench. Any errors in the affidavits that I'm sure will be presented belong to the affiant therein and to the affiance therein. The only time that the evidence will show that the plaintiff only actually met Linda when police were actually present. And he was actually the ones that contacted police, not because there was a problem on the property, but because he requested them go to the property with him prior to. At the end of the day, the evidence is going to show that there's no actual evidence of any assault that actually occurred, nor is there any evidence that Mr. Bench and Mr. Anderson met Linda together.
Yeah, we would call Mr. Anderson at this time.
Okay. Mr. Anderson, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Let's proceed.
Mr. Anderson, would you please state your name for the record?
Corey Anderson.
And you currently reside in Wiley, Texas.
Yes, sir.
And does Kenneth Bench reside in Wiley, Texas as well?
I have no idea.
Okay. And Mr. Anderson, in August of 2017, did you ever visit Dallas County?
Dallas County?
Yes.
No. I mean, August 17th. You mean the house?
I'm asking you, what first, is Wiley in Collin County or is it in Dallas County?
Colin.
Okay. So in in August of 2017, had you ever been in the county of Dallas?
No.
Okay. Now I'm gonna show you a picture of a black Ford pickup. Okay, Derek, will you go ahead and pull that up, please? And while he's doing that, did you own a black Ford pickup in August of 2017?
Yes, sir.
And does it have heavily tinted windows?
No, it has tinted windows, but not heavily, like they're legal.
Okay. Now, do you know what type of vehicle Kenneth Bench owned in 2017?
No, sir.
Yeah, this will be your exhibit 1.
Have you provided these to the court reporter, these exhibits?
This one I just recently.
What did you say? What did you say, Tony?
I didn't say anything, Judge.
Oh, you did? Okay.
No, I didn't.
Yeah, no, this one we did not. I just got this picture yesterday.
You need to provide all the exhibits with them numbered to the court reporter pursuant to the emergency order. So I don't want you just showing things on the screen the court reporter doesn't have. So what
Okay, go ahead and take it down, Derek. Yeah.
So what exhibits are you going to be using in this case? You need to forward those to the court reporter right now.
Okay. Derek, make sure you send those over to the court reporter.
Does he know what numbers they are and which ones they are?
Derek, make sure they have a number on each one.
Your Honor, if I may, this is Robert Newton. If we uploaded those through the filing system, does that count as submitting them to the court reporter?
Pursuant to the emergency order of the Dallas County District Judges, Dallas County Civil District Judges, you have to provide 1 day prior to trial a copy of all exhibits you're going to be using to the court reporter and to the court coordinator. Have you done that?
We sent it to the court coordinator. I don't believe we sent it to the court reporter, Your Honor.
Let me see. We did get some exhibits today. Can't connect. Why is it not connecting?
Judge Rhonda did forward some exhibits to me from Mr. Chu. It looks like 1 through 8 and 9.
Okay, so Mr. Chu, these need to, whatever you offer needs to match what you submitted to the court reporter. And exhibit 1, according to what you submitted, looks like it's the correction affidavit of facts concerning the identity of heirs. That seems to be exhibit 1.
My apologies, Your Honor. Again, this was a document. I keep thinking we're in court, and so this is a document I wanted to use, but I'll go ahead without it, Your Honor. It's not a problem. He's described the vehicle.
Okay.
All right. So, Mr. Anderson, did you understand my question earlier that when I asked you, had you ever been in Dallas County in August of 2017? Did you understand that question?
I understand it now, but do you have an exact date in August? And Dallas, I mean, I live on the border of Dallas County. Like my next across the street is Dallas County.
So therefore, it would be accurate to say that you had been in Dallas County in August of 2017.
Yes, sir.
Okay. Now, do you know the address of the house of Miss Bench?
I don't know where Miss Bench resides. I know the house that I took ownership of. Yes.
What is the address?
2210 Bombay.
So you're telling this court that you have no idea that Ms. Bench lived at that house in the past?
At some point, whenever I took ownership, the house was occupied by Jose Constello.
So objection non-responsive, Your Honor.
Overruled.
So you've never met Ms. Bench at the home that you claim you owned an interest in?
No, I mean, I've met her there with police officers. That's the only time I've ever met Miss Bench there.
Okay, very well. And so is it your testimony that you were never on that property with Kenneth Bench?
No, sir.
No, what, you've never been there, or no, you had been there?
The only time I was ever with Mr. Bench was when we drove by the property one day, but I never stepped foot on the property that day.
So you were in front of the property with Mr. Bench one day.
Yes, sir.
Do you remember whether or not that was in August of 2017?
It would have been September-ish.
And was he driving a red Mustang?
A later year.
Was he driving a red Mustang?
No, sir.
What was he driving?
Was a Jimmy, like little, I don't know, a Suburban or something. I don't know. It's a SUV.
Okay. Did you park in front of his vehicle in front of the house?
I just pulled up in front of the house.
Was his vehicle behind you or in front?
I have no idea, sir.
And did he have a passenger with him?
Yes, there was someone else present.
A female, correct?
Yes.
And you had a passenger with you, a male, correct?
No, sir.
So there was no one in your truck?
Would have been my wife, if anybody.
And did you ever step out of your vehicle in front of the house with Kenneth Bench?
Yes, sir.
And is your testimony that you did not walk onto the property?
Never been inside that property, sir.
I'm talking about on the property. That would include the outside.
Like sidewalk area, that's property?
Yes.
Yes.
So you did walk onto the property?
Yes.
And was there anyone outside of the house?
Jose Castillo was the only one ever there that day.
So did you knock on the door?
No, sir.
Can you describe Mr. Castillo?
Dark hair, tattoos, drove a black car.
Age, approximately?
Upper 20s, because he had children.
What was the nature of the conversation?
It was basically Mr. Bench saw, I guess, his nephew there. They hugged and said hello, and basically he told them that I was there to appraise the house, kind of take pictures and look at the outside, and he was selling the house to me.
Who was selling the house?
Mr. Bench was selling his interest to me.
At that point, you had not acquired an interest, is that correct?
No, sir.
Do you own a clipboard?
No, sir.
Did you ever have documents prepared transferring an interest of the house from a person named Linda Marquez?
Please repeat.
Had you ever had papers drawn up transferring an interest in the house that we're talking about to be signed by a Linda Marquez?
We had 3 deeds drafted, sir.
Okay. And are you aware now that Linda Marquez is not a real person?
No.
You understand that Linda Bench is her legal name?
No.
Who told you that Linda Bench is also known as Linda Marquez?
Dallas County sent me a thing saying Linda Marquez.
Yeah, I don't know what he's holding up. But
Dallas County water bill I received in the name of Linda Marquez.
Your Honor, okay, Mr. So was that, you're saying that was in September 2017?
No, this is still recently. I still always receive water bills and different things that say Linda Marquez on here.
I'm asking you whether or not the time that you were on the property was that in September 2017?
September 2017. Was I on the property? You're cutting out, Mr. Chu.
You just described that you were on the property in a black pickup Ford with your wife, possibly, correct?
Yes, sir.
And also you were on the property with Kenneth Bench.
Yes, sir.
And were you next to him when he hugged his nephew?
Yes, sir.
Okay. And was your wife with you on the porch?
No,
Where was she?
in the truck.
Now, did you get a chance to go inside the property since you testified that you wanted to appraise the property?
No, I've never been inside the property, sir.
Were you denied entry by Mr. Castillo?
No, I've never
Did
asked
you-
to go in the house.
Then you identify yourself as a buyer and you wanted to look at the house?
Yes.
So as a buyer interested in the house, wouldn't you want to see the inside?
I mean, I would like to, but I did not. I was not there to see the inside of the house that day. I was just looking at location.
What do you mean by that?
Basically, I've never seen the house before, and Mr. Bench came to me to try to sell his interest. So I said, well, show me the house. Like, let's drive by the house.
How much did you pay Mr. Bench for his interest?
Nothing. Well, I paid the back taxes. He approached me because the house was going up for auction on the courthouse steps. He asked me if I could save his parents' house and he would sign over his interest.
And you
that the
paid
city
him
would-
nothing?
Yes, sir.
Yeah, I will pass this witness.
Newton,
Yes, Your Honor. Mr. Anderson, who did you talk to on the property that day?
Jose Castillo, that identified as Linda Bench's child.
Did you speak with anyone else on the property?
Maybe an Al, a guy named Al.
And what do you recall any portion of your conversation with that Mr. Al?
Basically, I asked him how the neighborhood was, basically who the legal owners of the house were.
When reviewing properties to purchase, do you often see inside of properties?
Sometimes you can.
On this particular occasion, did you have any idea that you would actually be stopping at the property to speak with anybody?
No, I thought the house was vacant.
And did you ever assault Mr. or Mrs. Bench?
No,
Did you ever see Mrs. Bench that day?
no,
Did Kenneth Bench see Mrs. Bench while you were on the property?
no,
Did Mr. Bench ever go inside the property?
no,
Did Mr. Bench have any sort of altercation, physical or otherwise, with anyone on the property that day?
no, sir. It was a pleasant day. He actually hugged his nephew and said bye, and then I left, and that was it.
Would you have purchased the property if there had been a physical altercation?
No, I would have walked away.
Why?
Drama. It's too messy.
Thank you. I'll pass it with us, Your Honor.
Mr. Anderson, Is this the first time anyone ever has accused you of assault?
Yes.
So you weren't arrested in the past for assault?
Objection,
Deadly
Your
weapon.
Honor. This is not relevant to, or this is irrelevant evidence because there has been nothing proffered to suggest that there's been any sort of judgment against or guilt associated with any crime by Mr. Anderson to this court.
This is for impeachment, Your Honor. He just said no one's ever accused him.
Still, Your Honor, it lacks relevance.
I'll let you make a bill on this, Mr. Chu.
Yes, Your Honor. Thank you. Okay. So, Mr. Anderson, you testified that you prepared a document for Linda Marquez to sign, correct?
Correct.
This was before you had even met her, correct?
No.
So you met her and she agreed to sign a document with the name Linda Marquez transferring the property to you.
No, sir.
Then how did you come about preparing a legal document transferring an interest from Linda Marquez to you?
So how it transpired was whenever I took ownership of Mr. Bench's interest, we looked at other people that were on an affidavit of heirship. So we drafted deeds and we're going to buy those interests out.
This affidavit of heirship that you talked about did not have the name Linda Marquez on it, did it?
I haven't seen it in many years, so I don't know, sir.
The name was Linda Bench, wasn't it?
I haven't seen it in a while. I don't know what was on the affidavit. Okay. I could pull it if you would like.
All right. Well, we'll give you time to do that. I'll go ahead and pass the witness, Sean. I want to get to another witness.
Anything else, Mr. Newton?
Yes, Mr. Anderson.
Yes, sir.
Are you aware of how ownership of the property is maintained in with the Dallas Central Appraisal District?
Yes, sir.
And how is that stated?
Yeah, in the name of Corey Anderson and Linda Marquez.
Judge is not responsive.
Your Honor, that's actually exactly what I asked.
Overruled.
And do you know why the Dallas Central Appraisal District lists Corey Anderson as an owner of the property?
Yes.
Objection calls for speculation.
Overruled.
Do you have any involvement as to why the Dallas Central Appraisal District would list Linda Marquez as an owner of the property as opposed to Linda Bench?
No, sir.
Pass the witness, Your Honor.
Mr. Anderson, isn't it true that you were the one that notified the appraisal district that you own the property along with a person named Linda Marquez?
No, sir.
Pass the witness.
No further questions, Your Honor.
Okay,
Yeah.
call your next witness, Mr. Chu.
Yes, y'all will call Mr. Alfonso.
Okay, please, sir, please raise your right. Is he on the line? I don't see him. Let me see. Where's Mr. Alfonso? Is he here?
Yes, he's right here. I'm going to switch places with him.
They're in the same house.
Where's my picture?
Hello? Can you hear
Is
me?
your video on?
Yeah, I can't see it. Is he the Galaxy 21?
Hello?
Okay.
Yes, there you go. There you go, we can see you.
Sir, please raise your right hand. You swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
Nothing but the truth.
So is that a yes?
Yes.
Okay. Please state your full name and spell it for the record.
Alfonso Carrasco, Alfonso, Carrasco, Carrasco.
Okay. Go ahead, Mr. Chu.
Thank you, Mr. Carrasco. May I call you Alphonse?
Yes, or Al.
Alphonse, you're scheduled for dialysis this morning at 11. Is that correct?
Yeah.
Okay. So you saw Mr. Anderson testify just now. Is that correct?
That's correct.
And you were able to see his face?
Yes. That's
Do
him.
you remember ever seeing him in 2017?
Yes.
Okay. Can you tell us what you remember? Well, let's try that.
I remember.
Let me ask you the question. Okay. Did you see Mr. Anderson on the property?
Yes.
And the property talking about was what, 2210 Bombay Avenue, Dallas, Texas?
Yes, sir.
Okay. And was he on the porch?
Yes.
And who was there with him when you saw him?
Kenneth Bench.
Anyone else?
There was a girl with Kenneth in a red Mustang.
Was Linda Bench there?
Yes.
Okay. So earlier you heard him say he didn't see Linda Bench. Is that true?
No.
Did you see anything in Mr. Anderson's hand?
A clipboard with paper.
And did you see what he was doing with that clipboard?
He came at her and wanted he wanted to sign the papers and came out with the clipboard toward her face.
And you witnessed that?
Yes.
Now, what did you do when you saw that?
Well, I was wondering when I saw Kenneth come with him, I knew something was going to come up, and they wanted her to sign the papers, and she said no. And then Kenneth hollered at her, "You better sign these papers, or I'm going to kick your butt." And then Corey said, "Sign the papers," and then Kenneth punched Linda in the chest because he even threatened my life. And he went against Linda went against the wall, and then her hands were up in the air trying to block whatever they're hitting her with, and all this, and Linda was screaming and crying in anguish, and I just know Kenneth, and he just assaulted her, and then all of a sudden her son Castillo, Joe Boy, came out and got in between them, and then Corey was trying to grab her in the hands, and that's what I remembered. I called the police, 911, when Kenneth struck her, because I know it's gonna get bad, because he's always assaulting his sister. It's a shame, but it's true.
How long have you known Ms. Bench?
I've known Bench all her life.
Are you her neighbor?
Yes, I'm her neighbor.
Okay. And
I
do you
know her.
help her? Do you
Yes.
help her watch her dogs?
Yes, all the time.
So, did you witness Kenneth Bench hugging Mr. Castillo?
Hugging. I remember Castillo's getting right in between them so they wouldn't hit his mom.
I see. And was Miss Bench's daughter in the house at the time?
Yes, she was.
Okay. And when you say that Mr. Anderson was trying to hit her with a clipboard, did it look like he was doing it with the intent to do that?
Well, yes, he wanted her to sign that papers.
Can you demonstrate to the court how he was raising that clipboard?
Like this?
Two hands?
Mhm.
And he brought it close to her face?
Yes.
Is there any reason why you didn't attempt to restrain Mr. Anderson?
Well, I was on the other side behind the fence. That's why I called the police.
I see. And you say that there had been a history of violence with Kenneth Bench and you?
Objection, Your Honor.
Well, he threatened me 3 times, and I told him
Your Honor.
I told him if you hit me, I'm gonna get my lawyer and put him in jail. One time he put his foot between the door. The guy just
Objection, Your Honor. This is
he's no good.
irrelevant.
Same.
To be relevant. True.
So were you yourself in fear for what was happening to Linda that day?
Could you repeat that again?
Were you in fear of what was happening to Linda that
Yes.
day?
Yes.
What was that fear about?
He couldn't kill her. He's always screaming, I'm gonna kill you, I'm gonna kill you.
Okay.
He's told me that in the past.
That he wanted to kill you?
Objection, Your Honor. Non-responsive.
He did.
How big of a person is
Kenneth Bench
Kenneth?
is big enough to hurt somebody bad. Because people he bullies his way all his life. I mean,
Objection, Your Honor. Non-responsive.
Same.
it's true.
I'll pass the witness, Sean.
Cross.
Mr. Carrasco, how are you this morning?
Just fine.
Good. So how long have you lived on the neighboring property?
My property?
Yes.
Since 64, almost 60 years.
Oh, wow. And when did Mrs. Bench live on the property?
Probably late 60, 68, that range.
Okay. And when did do you know about when she moved out of the property?
No, I don't remember that.
Do you know about when she moved back into the property?
When she moved in?
Yes.
Well, she's been here a long time.
Has she lived there her entire life?
Almost.
What gaps exist?
Look, I can't remember the gap, but Linda's been here longer than Bubba and all that. Because Bubba left quick.
Who's Bubba?
Or Kenneth, excuse me, Kenneth Bench.
No problem. No problem.
Because
so was Mrs. Bench living there on the property in 2015?
Yes.
Was Miss Bench living on the property in 2016?
Yes.
Was Miss Bench living on the property from then until the present time?
Yes, she has. She's my neighbor.
Your Honor, if I may produce I don't know how to throw this up necessarily, but
Are you trying to share screen?
yes, I
So
apologize.
it should be in the middle. It should say share screen, and then you just click on it, then click on whatever you're trying to share.
All right, so share.
There you go.
There you go. Mr. Carrasco, can you see what I'm showing you currently? Can you
Yes.
see Mrs. And what does that appear to be?
That's Linda Bench.
Is that her driver's license?
I would think so. Yeah. It looked like it. That's a
Okay.
driver's license. Texas driver's license, yes.
And can you read for the court what it shows her address to be?
Yeah, I'm gonna object. The document speaks for itself.
Overruled, you can answer. You can answer, sir.
It's line 8, sir. Just to the right of her left shoulder.
I can read it. It says 200 Postwood Court. Is that what you're trying to get at?
Yes, Your Honor.
You may not be able to read it because it looks like he's on a phone.
Oh, okay. And Mr. Carrasco, can you read the issuance date on that driver's license?
Or like her address?
No, the date that the license was issued. Can you read that on your phone, or would you like me to tell that to you?
3/1/2017, right?
Correct.
Okay.
So would you agree with me that states that Mrs. Bench maybe did have some gap years from living on the property?
Well, I always saw her over here. She always took care of her mom and the kids.
Are you
Because
familiar with when her mother passed? What year that was?
I can't remember. Let's see. Was it 2015?
Close. It was 2013.
Okay, 2000.
So her mother would not have been alive in 2017. Let's see. Okay, now we hear of a will that was executed.
Yes.
Were you a witness to that will?
I signed it.
You signed it? What did the will say?
It said Jessie, her mom, was leaving the house to Linda and her two youngest kids, Samantha and Oliver. That way they have a place to stay and have a roof over their head. She told me that all the time.
Who is the executor of the will?
Executive. Well, it's supposed to go to Linda. I signed it.
How many pages was the will?
I think around maybe 5 pages, 6 pages.
And who notarized the will?
Mr. Camellia, off Harry Hines Roll 8. These apartments, those apartments in the very back, and she's the one that signed it. It was okay. I signed it. Mr. Steve Whittingham, who was the neighbor, Jesse signed it, and Camellia, the notarizer, she signed it.
What year was that?
Can't even remember right now, but she did sign. I did sign it. I remember because my handwriting it verifies it. Nobody can write like me.
So do you have a copy of what you signed?
No, but she did, but she put it in the garage with all her other papers.
Objection,
And,
Your Honor, non-responsive.
well, tell you the truth.
Overruled. You can finish.
And then Kenneth Bench, he came over one time looking for Linda.
Objection, Your Honor, non-responsive.
And he was in there tearing everything up. He says, I'm taking what I'm going to take. And he says, I'm going to kick her butt and my butt. And I go like, what? That boy is crazy. And he's a big guy. He's a big guy.
Do you recall about when that was, or when the will was, when you signed the will? Your Honor, I would have to instruct the witness not to look for advice on answers.
So you just need to answer the question. You can't get help from other people.
Okay. Well, I know we signed it before she passed because I always talk to her about it, and I go, Jesse, you got to sign a will. And finally, Steve and her son went and got the will. We filled it out, and we went over there toward the notary, the lady, the notarizer, Camellia. Her name was Camellia, but that was how we did it, because Jesse signed it over to Linda and the youngest kids. Because she said Kenneth Bench that has no authority over this house
Objection, Your
anymore.
Honor, non-responsive.
I'm just telling you what I saw.
Anything else?
Yes, Your Honor. What is the what was since you spoke about it as allowed, what was the alleged date that Kenneth stole the will?
He stole, well, it's hard to remember days. I know he stole it. I think after they came up here trying for her to sign the papers over. Corey wanted them to sign them papers. She said no. So
Was it on the same day?
no. It was later. Because he was in that garage. I saw him.
You saw him steal the will?
He had a bunch of stuff in his hand. He said, I'm going to take what's mine. As I remember saying him that. But
So if there's a bunch of stuff that was his, how do you know the will was in that lot?
because Linda, we put it in there, and she was going to make a big file in the house to put it in there, but he burst in there and took everything. You know, he's got no jurisdiction over here.
So
He left
what
a
all did
long
he
time
take?
ago. Huh?
What all did Mr. Bench allegedly take?
Papers, and he took, what did he take? He took something metal. I don't know if it was something that was his or something. Which
On what date, approximately on what date did that occur?
Well, I can't remember the dates. I'm just telling you what I saw.
Approximately on what date did the assault occur?
August 12th, 2017.
And how do you recall that date?
Yeah, because I was outside watering the yard and with my dog. And then when I saw them come up, I go, I don't know what's going on here. And then when I saw Kenneth, I knew what's going to happen because he's always hitting his sister.
Mr. Carrasco, you called the police allegedly, is that correct? That's your testimony?
Yes, because he hit her in the chest. And if I didn't call somebody quick, it would have hurt her real bad.
How many officers responded?
I think around 3. And he told her, the officer told Kenneth, he says, if you hit her, I'm taking you to jail or whoever.
Did he take her to jail?
Take who, Kenneth?
Yes.
No, he warned him. He was about to hit her. I saw him raise his fist. He says, you better not touch her or I'm going to take you to jail.
Are you aware of a police report?
The coward, huh?
Are you aware of any police report?
I don't know, one should have been written up. That's all I got to say because.
Did you take any pictures of the incident?
No.
Did you take any video of the incident?
No, I didn't. I should have, but I didn't.
Do you have a security camera on your house?
I did, but it's not copying, you know. I got me a new one though.
So the old one was non-functional, is your testimony?
No, it was working. But the thing about it is it's not copying. But I got me a new one.
So you have no videos or phone.
No.
Did you ever speak with Mr. Anderson?
Yes.
What was the nature of your conversation?
Well, he wanted to talk to Linda. And, you know, obviously for her to sign these papers, probably about the house.
And did you ever see a copy of the papers?
Yeah, I didn't read them, but I saw a bunch of papers.
A bunch of papers? How many?
Gosh, I can't count when they're in the clipboard, you know.
Approximately. Was it a stack?
About a fourth.
A fourth of a stack?
Yeah.
Maybe 50 pages, 100 pages?
No, it's maybe 25, 30.
No further questions, Your Honor. I'll pass the witness.
Response?
There are no further questions for this witness. May he be excused. He's got to go to dialysis.
Your Honor, I may want to call him back at a later time.
Did you subpoena him?
No, Your Honor.
All right. Mr. Carrasco, you may go forth. You are excused.
Thank you,
Judge, before he goes, can he spell Mr. Steve's last name? It wasn't that clear. I just need to make sure I have it.
Okay, it's Steve Whittington, Whittington. IGN Ton. Whittington.
Thank you.
You are excused.
Thank you. Thank you,
Now,
Judge.
Call your
we
next witness, Mr. Chu.
would call Oliver Marquez.
I'm here.
All right, so let's see, you need to turn your video on, sir. All right, sir, please raise your right hand. You swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
Yes.
All right, you may proceed.
You please state your name, sir.
Oliverto Matthew Marquez.
Now, you saw Mr. Anderson testify earlier, is that correct?
Wait, excuse me?
Did you see Mr. Corey Anderson testify?
Yes.
Okay. And have you ever seen him prior to today?
Have I ever seen him?
Yes.
Yes, many times.
And did you see him in 2017?
Yes.
Or was that the first time you saw him?
Yes, he pulled up. Well, he pulled up in a black Ford with tinted windows, and then a red Mustang came down, and the person that was driving the Mustang was Bubba. Well, his name's Kenneth, but I call him Bubba. His wife got out smoking, and Bubba was in the passenger seat, and they both arrived. Well, Bubba and we arrived together towards the port, coming through the driveway.
Very good. And did you see Mr. Anderson on the porch of 2210 Bombay Avenue?
Yes.
And was Kenneth Bench standing with him?
Not standing with him on the porch, but him and one time. Together.
And was there anything in Mr. Anderson's hand?
Yes, many times. Always papers.
What was in his hand besides the papers?
Oh, well, there was a clipboard involved. It was his first time with Bubba, Kenneth.
Okay. Right. And was Mr. Carrasco out there that day?
Yes, he was outside watering his yard in his yard.
And did the police come to the property that day?
Yes.
Okay. And when the police arrived, was Bubba and Corey Anderson still on the property?
Yeah. Corey was near the porch, and Bubba was by this tree that we had in the front yard. He backed up when he saw some police. When the police came, he backed up. Before that, I was looking on the camera, and I was seeing everything going on, and I got scared. And my sister and my brother was in the living room sleeping. I woke him up and said, "Hey, you need to go outside because Bubba's here." And he was like, "Who?" And I was like, "Bubba." He was like, "Oh no." So he got up and I gave him the shoes. He went out there. He got in the way of my mom because he know how Bubba is. And my brother, he's not, he don't deal with that. I called somebody down here. He said, "I'll be down here in a minute," because me and my sister were scared. I was like, "Samantha, just wait. He's coming." He came down before the police showed up. And then I said, "Okay, Samantha, let's go to Sammy," his name. I called him. It's like a stepdad to me. I was like, "Okay, you're here. We're safe." But then as soon as I seen Bubba approach to Sammy, I grabbed my sister and I walked back because I thought we were safe. But he went up to Bubba. No, he went up to Sammy saying, "You need to go back where you're at or I'll kick your ass."
Who said that?
Bubba.
And that's Kenneth Bench.
Yes.
And you stayed inside the house?
All the time until I went out with my brother.
Why did you stay in the house?
Because I was inside and I was watching TV, and then when I seen two cars pull up, I was scared because my mom was outside, and I was like, "Okay, I have my brother here," so I thought they would come to the door because, I know how Bubba is. I heard about him. Every time I see him, I get scared. He's a scary man.
And how old was your sister then?
She's a year below me, so I think when I was 7, I think I could say 16, 15, somewhere around there,
Okay.
between those ages.
Can you tell the court what you witnessed on the porch?
He came, he like over his head and put it in front of my mom. My mom flinched like this, and I seen it.
Sorry, when you say he, who are you talking about?
Corey Anderson.
The person that you saw testify earlier. Okay,
Yes.
Go ahead, continue, please.
And then he had swung it with both arms and went like that to my mom, and my mom dodged. And then that's when I seen Bubba on the camera hit my mom. And you know, if you hit it, she's gonna slip, so it hit her chest. And I heard her yell, so that's when I woke up my brother to go outside. He went outside and he didn't touch Bubba, but he got in the way of Bubba. So if he hit my mom, he wouldn't hit my mom. He'll hit Jose Castillo, my brother.
Can you tell us how your mother was emotionally after this incident?
Oh, always. She was always scared. I mean, we had to lock the door, and some at night times, she will go to sleep, and I'll be like, "Mom, just go ahead and go to sleep," because my brother worked overnight. He'll get back. He'll work at like 9:30. He'll come back at like 4:30. So I have to stay up all night just to make sure nothing happens. They don't come through the night or anything, because like I know how Bubba is. I mean, like I said, he's scary. I don't know what his intentions is. And I was like, I'm gonna just stay up until my brother gets here. And I was just praying to God every time I was at nighttime. I was just looking at the camera, just seeing if my brother can pull up any minute.
Did you notice that your mother was traumatized or not by this incident?
Yeah.
Objection, Your Honor. Speculation.
I'm asking him if he noticed, Your Honor. That's not
He noticed is
speculating.
fine. Don't speculate.
So can you answer that for us, please?
Excuse me?
Did you notice whether or not your mother was traumatized by this incident?
Yes.
Were you traumatized by it?
Yes. I mean, if she's scared, I'm gonna be scared. I mean, I always look up to my mom. I mean, she's older than me. And I thought, she'll always be there for me and, take care of me like she always does. But when in pain, I'm in pain because I don't,
We'll pass this witness, Your Honor.
Mr. Marquez, who are you exactly? What's your relationship to the family?
Son.
I'm sorry, I couldn't.
You cut out. What did you say?
Linda Bench's son.
So you're Linda Bench's son?
Yes.
So who is your father?
Roberto Marquez. I don't know if he has a last name, but yeah. I mean a middle name, sorry.
I'm sorry, I think we lost a picture or something.
Oh, that's Al. He didn't turn off his phone. You may go. I could go turn off the phone because he's gonna be like that. Because he's gonna.
That would be great.
Okay,
if that's okay, Your Honor. Is that okay, Your Honor?
I'm gonna mute. I'm gonna go ahead and mute him, and that should take care of it.
Never mind. He's gonna go to do it. The census lawyer, I think.
Mr. Marquez.
Yes.
So, was your mother ever married to your father?
No.
So you said you had a camera and that you were rolling at the time of, that was your testimony, that you were rolling the day, that you were shooting camera at the time of the incident. Is that correct?
Yes, I was looking at the camera.
And so did you capture any video of the incident?
Repeat that again.
Did you capture any video of the alleged incident?
No, I just seen all of it. It was recording, but then somehow, I think like 3 weeks after the incident, cameras were cut and we were shocked. I mean,
I'm talking about, this was on your phone or is this your security camera?
It was a security camera, but every time they came, my mom wasn't here. So I'll try to take a picture of all the cars that came and every person that came.
Okay, so you actually have had pictures and video of the alleged incident. Is that correct?
Not when they pulled up, like not when this incident was here, like the first time they came together. No, I just seen that in my,
It was your testimony that you were in the house watching the
Yeah.
camera
Yes,
on the date of the alleged incident.
yes.
And so where's that footage?
I mean, the cameras were cut. I mean, we couldn't.
What do you mean by it was cut?
I mean, we had wireless and we had them around the house, and they cut the cameras, and we couldn't get the footage back. We had to buy new cameras. My brother did.
But that wouldn't, so your testimony is that subsequent to the alleged assault and subsequent to, or while the police were out there, that they went and cut the wires to the camera.
Well, I don't know if Corey and them cut it. I'm just saying someone else could have cut it, but the cops did come out that day.
And somebody cut the cameras after the alleged incident. Cut the wires to the camera after the alleged incident.
The wires were cut after the incident, but it was not like right after. It was like a 2 week ahead or 3 weeks ahead after the incident.
You said this was a wireless system.
Yeah.
So what wires did they cut?
That goes to the box through here and goes outside and goes to the by the garage.
But there wouldn't, in a wireless system, the camera is wireless. There are no wires.
Well, there was wires, so they had to be cut. I mean, we've seen them cut.
And so what happened to the video footage though? Because that would just cut the video. That doesn't cut what was already shot.
Well, I don't know where the video was. I mean, I've been telling my brother we can look for anything to help out.
I mean, we're here at trial. It would probably be, do you agree that it would be helpful to have that footage?
I mean, yeah, but I mean, I don't have it. I mean, I would be glad to get it.
Have you searched for it?
I've been searching for it, yes. It's always help.
So how many police officers responded?
How they responded?
How many police officers responded?
3.
Do you have their names?
No.
Did they take down your name?
No, they took out mom's.
Did you provide a statement?
No.
So as a witness to an alleged assault, the police department did not take the names and statements of the parties present?
No, they just came out and then they just escort Bubba and what's it called, Corey, to leave. And after they left, they just took off, the police.
Did they speak to Mr. Anderson or Mr. Bench?
I think they speak to Corey Anderson, but I don't think they speak to Ben. I mean, Kenneth Bench, because he just took off as soon as the police showed up. He just started walking back to his red car in the Mustang, and he took off.
I thought it was your testimony that, or no, it was Mr. Carrasco's testimony that Mr. Bench was attempting to hit your mother while the police were there, and they warned him that they would arrest him if they did. So that did not occur?
No, it was Anderson. He tried to grab my mom. He was grabbing my mom's hand from walking inside because my brother was telling my mom to go inside because my mom was scared. She was nervous.
I believe the testimony is that it was Mr. Bench that grabbed your mother.
No.
Objection, Your Honor.
Before
Counsel is mischaracterizing the testimony.
Yeah, I mean, I think the more appropriate thing is just to ask him the question, and then if he can answer it or not. So you're trying to provide what your summary is of the testimony, and I don't know if he was even here for that. So I don't know that that's appropriate cross-examination.
Thank you, Your Honor.
Do you have anything else, Mr. Newton?
Yes, Your Honor. So you stated that you were in the house the entire time. Is that correct?
Yep. Yes, sir.
Where were you inside the house?
Right there by the TV. Right there in
Yeah.
front of
And so does that look onto the front door?
the front door, the side of the garage, the other side of the house.
So how were you able to witness the incident?
I mean, as soon as I seen them both walked up, I was like, "Who's this?" And I peeked through the window, and I just recognized Bubba, and I was like, "Oh snap!" And then all I seen was they both came at her. He had got the clipboard. He went over. Bubba had said, "You're gonna sign these papers, or I'm gonna kill you." And then that's when he had swung. He hit my mom. My mom had dodged like this. She fell, and I heard her scream. So at that time, I glanced away from the camera. I woke up my brother and said, "Go out there and help mom," because I was scared. So he went out there, and then Al had called the police. I called the guy to come down to help us. And then that's when Bubba had pulled up on my stepdad. I call him my stepdad.
Who is your stepdad?
Sammy. He's not a stepdad, but I call him a stepdad. He's like a father figure to me.
And so he pulled up as well?
Yes, he pulled up as well.
So was he there when the police were there?
No, because Bubba told him to leave. I mean, he couldn't do nothing. I mean, he came to the yard. He didn't even try to go to Bubba, no Anderson. He just tried to come to get
So
us.
who's your stepdad in relation to your mother?
Oh, they never dated.
No, I'm just asking, who is your stepdad in relation to your mother? Like,
Oh.
why do you call him your stepdad?
Oh, I mean, he's always a father to me. I mean, my father never been around my father. I always got abused, and I was always with my mom, just like my sister.
So he supposedly saw an assault occurring against your mother and then just turned around and left.
Who, Sammy?
Yes.
Yes, he came trying to get us to take us away because we were scared. But then, like I said, when Bubba approached Sammy, I backed up and I was holding my sister. I was like, "Hold on, go back." And then that's when Joe Boy had sent my mom inside, and Anderson was grabbing my mom. And then that's when Sammy had left because Bubba was like, "Get out of here! I'm gonna kick your ass." And Sammy didn't want no part of it. So Sammy was already walking, and he was like, "Okay, what I do now?" So when he was walking up, the police had came around the corner that Al called. And then that's when the officers were pulled up and Bubba had backed up. And then Anderson was holding my mom's wrist and they were saying, "Hey, you better let go of her. We're going to take you to jail to sign the papers."
So the police threatened to threatened to arrest Mr. Anderson as well, is your testimony?
Yes.
Why did the police not arrest anybody?
I mean, because they
It
didn't.
calls for speculation, Your Honor.
In your opinion, why did
Only testify if you know the answer to that. Don't try to guess.
Excuse me?
Only answer that question if you know the answer. Don't try to guess.
Okay, go ahead and repeat the question. Let me see what's.
I'll rephrase the question, Your Honor.
Yeah, there you go.
Did the police witness anyone touching Mrs. Bench?
I don't understand the question.
Did the police see any physical altercation whatsoever?
Yes, the Corey Anderson holding my mom's hand.
And they failed to, and you did not see, did you see the police take Mr. Anderson's information?
I think, well, no, I didn't see nothing.
They did not take his driver's license, a copy of their driver's license?
They did take driver's license, but I don't know if they asked some information, but I did see him pull out his wallet and his driver's license.
And what was the date of the alleged assault?
August 12th, 2017.
And how do you recall that date specifically?
I mean, I always knew it. I mean, scared. And then my mom always told me, "Hey, always, beware now."
Has your mother, well, never mind. What was it? Do you know what was in the stack of papers that Mr. Anderson was trying to get your mother to sign?
For the house, trying to buy the house.
And how do you know that?
Because like Bubba said, you're going to sign these papers to give me this house or to sell the.
And how many pages approximately were on the clipboard?
Like that much.
Do you know how many pages a deed is?
Excuse me?
Do you know how many pages a typical deed is?
No. But Corey has came many times with the papers, stick them on the door and took pictures, and has sent many people too.
Has Corey ever come to the house with police before?
One time.
Just once?
Just once.
And did you get a picture of that?
Excuse me?
Did you have a picture of that incident?
Or
video?
No, but I know the officer has. I know the officer does because my mom had asked the officer, "Hey, are you recording?" And he said yes. And then that's when my mom had went out there and she had asked for a sergeant and then started talking to him, telling him everything. And then the sergeant was getting kind of nervous. I don't know why. I guess because how my mom was reacting and she was scared. And then we asked for a constable. And then after that, they before they took off, my mom had went to go take a picture of his truck and his license plate, because now we have to be aware of, if we see that truck in the neighborhood, we have to be aware of if we get any contact with them, like if they come and try to kidnap us or hurt us or anything. And I remember this. I was on the porch and my mom was walking towards me and I was looking at my mom, and I remember Corey doing the action of like two hands going towards his, private part. And then he stick the finger at my mom. And I said, I was like, "Mom, you didn't see what he just did?"
Unresponsive. Objection, non-responsive.
And
What was the purpose of the visit with the police officers? Because in that incident, it's your testimony that Corey requested the police officers to come with him. Is that correct?
Yes, just to give the papers.
What were those papers?
The same papers that he always comes with.
And now you said that was a notice. Was that notice left on? Was that notice left with you, or left on the premises?
I was left on the window.
What did that notice say?
I don't know. I never read it. I just left it on the table, and then every time, when my mom walked through the door, because she wasn't here, she was scared. I was always by myself, and every time he came, I locked the door. And sometimes I heard the door, the knob shake. So I was like, "Oh, he must be trying to come in." So I'm glad I locked the door. And every time he took off, I went outside, I took the paper, put it on the.
And how many pages were those papers?
It was just, every time he came by himself, it was just one paper.
Okay. Have you ever seen the deeds that purportedly transfer Kenneth's interest to Corey?
No.
I'll pass the witness, Your Honor.
No further questions, Your Honor.
Okay, so how many more witnesses do we have here? Because I have other hearings I've got to get to. So how many more?
Ms. Bench is my next and last witness, Your Honor.
Mr. Newton, how many witnesses do you have?
I'll have Mr. Anderson, and that will be it, Your Honor.
So there's been a lot of testimony about photos that were taken and police called and video footage. Is any of that going to be introduced at trial? Are we going to have any of those exhibits offered? They haven't been offered yet.
No, Your Honor.
I will introduce some pictures in a video, Your Honor.
Involving the assault?
Establishing that the times that my client were present with Mrs. Bench, he had always requested officers, and that we actually have video and pictures of him with the officers. It's not the date of the incident. My client was not there on the date of the alleged incident.
Yeah, and we'll be objecting to the relevancy of your honor.
All right, we'll see about that. Okay, why don't you guys just wait around, I guess? Your witnesses can leave if they've already testified. I don't know how long these other hearings are going to take, but we'll get to those. Or I can just have you guys come back at 1:30 if you don't want to wait around.
At 1:30.
Or actually, let's say 1 o'clock.
I can wait. It's up to whatever's better for the court, Your Honor.
1:30 be fine with us, Your Honor.
I'm just worried that I'm not going to get to you, and then I have another Zoom thing I have to do at noon, so I'm going to have to break from about noon to 1. So that's why I was suggesting maybe you just come back. But if you want to wait around in hopes that we get through with these other hearings, I just don't want to.
No, you know, I'd rather schedule a time so just so that everybody can have a lunch break. Can we maybe do it at 2 o'clock Central Time?
I may run out of time then. We need to do 1:30.
1:30. Okay, yeah, that's fine.
Okay. You guys come back at 1:30, and is there any chance you guys can get this thing settled?
I will talk to counsel again now that he's heard the testimony.
Okay. All right, you guys, we'll see you back at 1:30. Let Rhonda know if the case settles, okay?
Thank you,
Yes,
Your
Your Honor,
Honor.
we certainly will.
Thank you, guys.
Have a good day, or I'll see
Oh,
you
yeah,
at
can you put
1:30.
us in a breakout room?
Oh, you want me to put you in a breakout room? Who needs
Yes.
to go in the breakout room?
Just Mr. Nicely, Mr. Newsom, and myself.
Nice. What is nice? William Knight. Oh,
Right here, Your Honor, if that helps.
I don't know how to. You guys are already assigned to that breakout room. Let me do this. All right.
Close it.
Did you guys get an invitation?
I got to hear you.
Yes, sir.
Okay.
Thank you, Your Honor.
Okay, good luck, guys. All right, I'm going to call the next hearing. Okay, Charles Zubarek versus Francisco Gonzalez. Is everyone here on that case?
Plaintiff's here, Judge.
Anyone else here on that case?
Third-party defendants are here.
Ms. Coker, who else is here for that case?
Mr. Milligan, Mr. Fell are here as well.
Craig, you're muted.
Third-party defendant is here, Your Honor.
Is that, I can't hear, is that Gizem Patriciono? Okay. And Mr. Milligan?
Mr. Kramer. Mr. Kramer is here.
Okay, got it, Mr. Kramer. Anyone else? There's a noise coming from Mr. Milligan, I believe.
Hold on, let me mute. Oh, good call.
Okay, that was it, definitely from Mr. Milligan. All right, we're here on a motion for continuance. Let's proceed.
Yes, Your Honor. We filed our motion on August 2nd. As you may be aware, there was a hearing on July 12th, and even during that hearing, plaintiff's counsel acknowledged that as we consolidated 2 of these cases and they brought new claims against the HOA, including breach of fiduciary duty, this is no longer just about utility easements and fences. And within this time period, we really didn't have enough time to conduct any discovery, and we are at this time in the position that we need additional time to conduct written discovery and take depositions. That's why we respectfully request a continuance on the trial that's supposed to go August 17.
Response?
Judge, I don't think more time's needed. The case is what the case is. We're set for trial. This is an older case. That said, I don't even know if we're going to get reached for trial. Obviously, the new corona's coming around, so I'll leave it to the court's discretion. But plaintiff is ready, and I think this case needs to be tried.
So let me say this, separate out the issue of whether or not discovery needs to occur. I'm not going to comment on that yet, but let me just kind of talk to you about where we are on the coronavirus and the court's response to the COVID and the recent escalation to a red threat level for Dallas County is that our local administrative district judge has enacted a new rules that do allow us to go to trial, but makes it very, very difficult, unfortunately, to in practice to do this. So some of the limitations we would have to do if we're going to go to trial, Mr. Welch, is that everyone would have to wear a mask for the entire trial. So there's not going to be any type of, at one point we were allowed to have some discretion on that. Everybody would have to wear a mask the entire time. If you have a 12-person jury, given the size of my courtroom, we would have to request from the that jury selection be conducted in the central jury room, and we would have to get in line with all the other judges who may want to do jury selection. There's only going to be one jury per day in the central jury room for a 12-person jury trial, if you want 12 persons. If you want a 12-person panel, and I don't know that you do or you don't, but if anybody wants a 12-person panel, we're only allowed to have, besides court staff, we're only allowed to have 16 people in the courtroom. And so with 12 jurors, we'd only be allowed to have 4 people in the courtroom. And there's more than 4 attorneys here. So you'd have to agree to some kind of rotation, who is going to actually be in the courtroom at what time. And then I also have a special setting that week, so that has agreed to a 6-person panel. Now that case may or may not go. It could settle, but it's a pretty hotly contested family dispute over a large trust that I don't think is going to settle. So all that being said, I'm not trying to keep anyone from going to trial. I like going to trial. I'm very, but I just think logistically under COVID, it's just going to be very difficult to do that as long as we're in red, unless you guys can agree to all of you can agree to a 6-person jury panel, and then we might be able to do this. It'd still be tough, probably not that week, but we could do it fairly soon. And so, Mr. Welch, given all of that, what are your thoughts?
I'm willing to agree to a 6-person panel, but I can almost guarantee you, I can see Mr. Kramer shaking his head no. So I don't think we're going to reach that agreement. So
and just from I hate to say, just from a logistical standpoint of having to rotate in and out of we do have more than just if every party had a single attorney in the courtroom, we're still going to exceed the 16 limit with a 12-person jury. So I'm not wild about that idea.
Well, it sounds like we kind of have to continue this, because I don't know how I can compel you guys will you guys agree to a rotation, the defendants, if we do a 12-person panel, would you want to all be there at all times during the trial? I know a rotation would be difficult because you're not all going to be hearing the same evidence, so it would be hard to try this, but would you agree to a rotation?
I don't think I could do that on behalf of my client. I'm just not comfortable not being in the courtroom during a trial and hearing everything live to be able to.
Yeah, I don't blame you. So what?
I don't think that's feasible, Judge. I wouldn't ask them to do that, honestly. So
okay, and I'm not trying to be difficult with anyone. These are the
protocols. And I don't take it that way at all. It is what it is. Yeah. We're all stuck with it.
Yeah, I wish we weren't. Ms. Coker seems to have disappeared. Let me see I think she may be rejoining us. There you are, Ms. Coker. You disappeared for a second. So I think that what we need to do at this point is to go ahead and figure out, when you guys want to be reset. I would urge you, and your guess is as good as mine about how long this surge is going to take place. I was kind of ready to for this to be over, and it clearly is not over. And so
I think we all were.
and so what what is y'all's thoughts about a reset, Mr. Welch? When would you feel a reset would be okay, or when would you like to get a reset?
As a plaintiff lawyer, I'd want tomorrow, but sadly, it seems like we're just getting into this COVID stuff, so I wouldn't be surprised if it's next year before this kind of clears up. But I'm happy to get with counsel and.
Well, let's pick a date because there are other issues besides just COVID in terms of special settings and all that kind of stuff. And so let's pick a date. And you know what? I'm just when it comes to this stuff, I'm just as much in the dark as you guys are about when this is going to be over. I'm shocked we are where we are, and now there's supposedly maybe another new variant coming that's worse than Delta. I don't know. I hope that's not the case, but I've read something about that. So I don't know. Mr. Welch, when would you like it to be reset, and understanding that if we're still in red, then we probably will get reset again? When would be your preferred date given the situation?
February 14.
Okay.
February 14.
That's not unreasonable. What about everyone else?
His date's farther out than I was going to say, so I'm okay with that.
I've got an arbitration the week before, I'd say that, but the 14th is kind of my first availability that I think we're in the clear zone.
Okay, I'm okay. We're at least
Wife
in the
will object to
homeowners
February
association, we're okay with
14th.
that.
She'll object anyway, so I think that works for us.
Who's going to object?
My wife, because it's Valentine's Day.
It'll actually be on the 15th, just so you know. We try cases on Tuesday, so it'll be on the 15th. Does that work with you, Ms. Coker?
Judge, I'm looking at my calendar. I know I have an arbitration that's for some reason not on my calendar, but that's the first half of February. I think the 15th would be okay. I am also going to urge Mr. Milligan's stance. Valentine's Day will be fun. But yeah, that'll.
Well, let me check. Rhonda's 15th. Do we have a special setting on the 15th, Rhonda? How about Miss Patri? And I'm sorry, I don't know how to say your name. Miss Petros.
Okay. It's Petrosino. I'm with Mr. Kramer, so we're good.
Okay. She's looking up if we have a special setting that week. So look at the 15th and the 22nd, Miss Rhonda.
Judge, may I raise a related issue while we're discussing this? This is Greg Fell, representing Gonzalez's. We have this new party, this new case that's been consolidated into this existing case, and I heard counsel say that they're going to want to engage in discovery in that. I would suggest and would hope we could agree to a scheduling order. I have no idea what these depositions are going to bring forth and whether or not that affects the existing experts that we've designated. I'd just like the opportunity to have those deadlines open back up again, just in case.
Don't have a special setting on the 15th. Let me say one other thing that I think you guys should consider, and I'm trying to think logistically how to do this, but if you really want Mr. Welch for this to continue to be consolidated, is there a way that we can have, I'm just trying to think out loud here.
Bifurcate them somehow?
Bifurcate them or have a separate discovery plan for each case and then consolidate the trial, if that makes sense, so that like not all of the attorneys have to take discovery in both. Like I imagine there might be quite a few things that, for example, Ms. Coker's client doesn't really need to be there. Ms. Coker doesn't need to necessarily be there for all of the depositions that are solely related to the other case or the case of the breach of fiduciary duty case. And so maybe there could be some kind of designation of like, okay, this is just for that issue. You get what I'm trying to get at is.
Yeah, you're trying to say, look, as opposed to open up the whole can of worms, can we somehow have a focused track, I suppose, that would just concentrate on the new allegations?
Something like that, or if Mr. Welch or anybody wants to conduct discovery, you have to designate, is it
one or both or all, or?
Yeah, one or both or all, something like that. I'm not going to mandate that, but I do worry that there's going to be a lot of stuff here that that just aren't, that Ms. Coker and the other individual defendants' clients are not going to have to be there for, and I don't want to have to force them to be there. But I also, I know, they're all of you guys are very, careful attorneys, and so you want to be there diligent. You want to be there for any depositions and discovery that is relevant, that could be relevant. And so if there's a way to maybe require each party, if they're going to take a deposition, to designate, okay, what is this for, so that Ms. Coker and the other individual defendant attorneys can decide, okay, I don't really need to be there because it doesn't cover what we've already done. And I also don't want to reopen discovery on the original case, on the easements case, I'll call it. I think that's done. So the only discovery I would want to have at this point, and without leave, would be involving the new claims. Does that make sense?
It does.
Yeah, Judge, and the only thing I'd say is we're all the same counsel for both cases, so there won't be a lot of overlap, I think. I think everyone's aware of what happened in the depots already. But at the same time, like Ms. Coker's client is the president of the board, and it's a claim against the HOA and stuff. So there will be, I don't think I necessarily need any discovery, but I need to see what they're going to do. So I don't know what the HOA plans as far as discovery goes.
I'm just suggesting that you think through that. Maybe I didn't realize that about Ms. Coker's client. So, but there may be individual property owners who are not on the board that really that only are dealing with the easement issue, or is there anyone in that category? That's what I guess I'm trying to.
I think there's I don't want to speak for all the defendants, but I think there's a couple that might fall into that category, but I think maybe 3 of them at least were on the board at some point.
Judge, all of my clients either are or have been on the board in the past. That being said, I don't believe the fiduciary duty defenses are within my purview of my representation. So I agree with that whole concept. While we're here, there is just simply one issue as to a motion to quash third-party depots that the discovery period, there was, some disagreement as to that, but I'm happy to discuss that with you at a different time if that's okay.
Yeah, let's do that. Anyway, we're just think about how you can try to make the discovery more, so people don't have to show up to the depositions that I don't need to be at, I guess is my main thing. But if there's no way to do it, there's no way to do it. So we're going to reset this to February 15th, and we'll go ahead and send you guys a new trial notice, okay?
Thank you for your time today, Your Honor.
Thank you, guys. You guys be safe, okay?
Thank you, Judge.
Okay. All right. Let's deal with the Moss case next. Mr. Capua is here for that. Mr. White is here for that.
Mr. DuBose is here.
Mr. DuBose is here for that. Mr. Moss is here for that. Is Mr. McGuire, is he here for this case too?
Good morning, Your Honor. No, I'm here, but I'm here for the following setting.
Okay. Brandon K., what are you here for?
Yes, Your Honor. I'm the representative for fetal isthmus plaintiffs.
Okay. And Miss Newsom, what are you here for?
Your Honor, I'm here for cause number DC 20-09893, the matter of David Taylor Moss and Marco Princip.
Okay. Just making sure we have everyone here. All right, let's go ahead and get started. I know we're going to want this on the record, so Mr. Capua, if you could go ahead and announce the case name and cause number, and Tony, we need to go on the record for this.
Yes, Judge.
Oh, good morning, Your Honor. This is Craig Capua. The style of the case is David Tyler Moss et al. Versus Marco Princep et al. Cause number DC 20-09893. And I'm here today on behalf of the plaintiffs / judgment creditors and ready.
Your Honor, I'm Gene Dubose for the defendant Holly Bone, and this is our motion to vacate turnover orders.
Your Honor, Jervon Newsom here on behalf of the Google non-parties, and just here to observe and to see if Your Honor has any questions for Google.
Thank you. Anybody else want to make an announcement?
Dan Wide, co-counsel with Mr. Capua for the plaintiffs and judgment creditors.
Okay. Anybody else? I've read all the briefing on this motion to vacate. It doesn't seem to really cover any new ground. We do have a trial coming up on this case in October 5th. Mr. DeBose, is there anything new that that's come up that I should change my previous view on this?
Well, I don't think this has been before you, Your Honor. This is with respect to the turnover orders. One of the things that I found in preparing the appeal on the temporary injunction is that it's almost impossible for me to figure out under what order Ms. Bone's funds have been sequestered and her access to her channels taken away. You know, one of the things is you talk about the money that was put in the registry of the court. Some of that was taken out of her account in England to be put there. So it's not unclear whose money went in there. It was in an account only in her name, and all those records are before the court. And it was taken out and put into the court. The question here is, again, a due process claim. And the Texas courts are absolutely uniform that the rights of a third party cannot be determined by an ex parte turnover order. There has to be some sort of hearing, some sort of proof. Both of the cases that the plaintiffs have cited to justify their activity involved cases where the party whose rights were infringed upon was there and had the ability to testify. Ms. Bone wasn't a party at the time of that first turnover order. All that happened in the pleadings that were put before the court is her name was mentioned, and that was enough to get her stuck into a turnover order. Turnover orders can go beyond.
Well, let's make it clear. We haven't done a turnover order as to any of Ms. Bone's accounts. We have done a turnover order as to proceeds arising out of YouTube channels that the judgment debtor in this case has previously stated in sworn documents in other courts that he owned, right? We haven't turned over any of her accounts.
No, well, you have. You've taken money out of her account.
Out of her bank account.
Out of her bank account.
Money that was in her bank account has been taken out of her bank. Okay.
Yes.
That's not my understanding.
Well, that's the case. I believe I've cited to the location of that. We provided, if you remember, all the money from those channels went through an entity, a multi-channel network called Freedom Family Limited. Freedom Family Limited took all those funds and they put every penny that came through in the period that they were managing those channels, which was from 2019 until they were cut off at the end of 2020. Every penny went into Ms. Bone's accounts, first here in the United States and then in Great Britain. And if you look at those accounts, the last entry I have in there is money being refunded to Freedom Family Limited out of her account. And that's money that went into the registry of the court. But again, it's her rights. And these are in fact her channels. The only thing you have is a statement in his divorce that says, and I quote this in my reply, there's an order that says that his wife has no rights to what they called his YouTube channel, Futuristic Hub Business. Now, a divorce decree cannot define a third party's rights. What they were doing in that order is they're dividing up who's got income coming. And at that time, Mr. Martin was the manager of that account, and he was getting income from it. It wasn't until the
If
next
I recall,
month.
Mr. Martin is your client's husband, the judgment debtor.
Yes,
correct?
correct. And
there's an
he
$18
had been
million
shepherding her through this because you
And
remember
there's
she
a-
started.
And there's an $18 million fraud judgment against him, correct?
Yeah, it depends. I'm not sure of the exact calculations. I think there are two $6 million personal judgments against him.
I thought it was.
And pardon?
I thought it was 18 million. Is that not right, Mr.
Well,
Kaplan?
when I go, it may have been increased with interest on that, but there are two separate judgments against him. Large numbers get thrown around. I just went back to the judgment itself. In any case, it's a lot of money. The next month, she took the managership away from him. Her testimony has been she had no awareness of the judgment until the next year. And she assigned the funds, which only the owner of the channel can do, to Freedom Family Limited. Freedom Family Limited is where these channels really started to make money. Before that, they were pretty small. It went up 67% in about a 6-month or 7-month period. They know their business. They knew their business. Google's put them out of business now. But so that we get to these $100,000 a month amounts that were being churned out, that money was going only into her account, and it has been taken away from her. The point is that with both these we have two turnover orders. You cannot establish the right of a third party, and certainly that issue has been raised, and there's plenty of documentary evidence of her ownership of these channels. Remember, she was not at the temporary injunction hearing. She was not given notice of that. And if she had been given notice 2 days before, it would not have been sufficient. Notice means time to get a lawyer, because she didn't have a lawyer at the time for him to prepare for a hearing. None of that happened. So she has had this stuff ripped away from her by orders that cannot apply. Her name appears in that first order. She wasn't a party. All they do is mention in that when they're applying for the turnover order, they just say.
And the turnover order, I want to make sure I'm recalling this correctly. The turnover order does not in any way order that any funds be taken from Holly Bone. It's simply from these YouTube channels, correct?
Well, what it says is the judgment creditors asked to include Holly Martin into the order. Now, that's just not right, because this is actually not so much a turnover over as a preliminary injunction. As the Supreme Court decided in the Alexander DuBose cases a couple of years ago, turnover orders are fine. You take the money, you give it to the other side. When, however, something is left continue, and obviously this has been put into the registry of the court, abiding some later judgment, then this is not truly a turnover order. But the order was going against her personally. Shouldn't have been that. And at that point, there was no evidence whatsoever of the ownership of these channels, other than than the plaintiff saying, "Oh, it's his channel," and that is wrong, Your Honor. It violates due process, and as I say, in appeal, I really don't know which particular order has, we've got a temporary injunction and 2 turnover orders, one of which goes against Google, and Google is now out of that. However, Google's still going along with it. I don't know which one of those orders is the actual responsible order, and I don't know that anybody can say, because they've been all mixed together. With respect to the order, the Google turnover order in November, it said, by the way, this includes the first turnover order and it includes the temporary injunction, which hadn't heretofore been applied against them. It's a nasty can of worms, and I can't figure out exactly where it is, but I'm trying to get rid of all the things that could possibly be in it. And frankly, I think Google is a party to this case, because they have come, they sit in on the hearings, after they were ordered, the orders against them were taken away, they continued to participate. They've been giving information to the court, and I think they need to be joined as a party so that discovery can be taken against them, because they are the owners of all kinds of records. And in this court, they sort of fumble around, oh, I don't know about this, I don't know about that. But there's a lot of stuff. For example, both those channels have an owner to them that appears in their records, and we have provided those records. And what you do when you have a live YouTube channel is you have a password, and the password opens up and it says something, it says primary owner. And the primary owner of both those channels is and has been forever Holly Bone. A lot of people make up a name. She didn't. She started this when she was 13 years old. It was a lark. It wasn't a business. She was too young to think of making a living, but it prospered because she's something of a genius. And all those videos have been made by her. But I think Google has to be brought into this lawsuit because of their activity in this lawsuit. They say, oh, we only appeared under a protected provision. We're not really involved. They're involved up to their ears. And I will be trying to bring them in for discovery purposes on that basis, because it's right now, I don't know what order there is that has taken Ms. Bone's money away. I don't know what order it is that has cut her off from these channels. She can't put more content on them so that the $100,000 a month income was reduced a couple
Mr.
months
Dubois,
ago to $22,000.
there's a very simple solution to all of this. It is, there's a couple. One is that we need to get to trial. It's in October, I think, on this issue. Her husband has not been cooperating with discovery. He's fled the country. And I don't have any opposition to you conducting discovery as to Google. We've had quite a bit of discovery as to Google so far. And we'll make a determination in October. I think that's when the trial is set on who owns these channels. And so, but if there is some confusion as to which order is doing this, if there's any orders out there that are taking money directly out of Ms. Bone's account, that should not be the case. But it should be these channels. In some court documents, it says that the judgment debtor owns it. I guess in other things, it says that Ms. Bone enters it, and we just need to make a determination. It would be very helpful if Mr. Martin would participate and be a part of this so that we could hear his side of the story and explanation. Obviously, it's very, very suspicious that the judgment debtor's wife all of a sudden owns all of these properties when in the past they've taken the position that he owned all of it. Once he gets a judgment, now she owns it. That's suspicious. That's why I've frozen these accounts, and so that if it turns out that Mr. Martin, who has fled the country again and has an $18 million fraud judgment against him, and maybe not 18 million, but that's what it's been represented in the past. If he would participate, we'd be able to have a better idea of exactly what's going on. But for now, we just need to, I think, keep the status quo. Unless Mr. Capua, there may be a reason that we need to vacate one of these, that you have to defend these on appeal. And so I'm okay with vacating. There's been a lot of orders I agree with Mr. DeBose. There's been quite a few orders that have been submitted in this case, and it's been a little bit tortured history. So, but Mr. Capua, any of these orders need to be vacated to help your chances on appeal?
No, Your Honor, I'm fine with the current status of the orders.
Mr. DeBose, I would just ask your client to have her husband participate. This is really, if she really is the owner, and I don't believe she is, but if she really is the owner, it's his actions that are causing all this to happen. He's not cooperating with any court proceeding at this point. He's fled the country. And we have this $18 million judgment that has to be, that there's an attempt to try to collect. And if he would participate, it would make this all a lot quicker and easier, and we could figure out kind of how to go forward. But he's fled the country and is refusing. And I understand that is she still in England as well? Is she also?
Oh yeah, she's a British citizen. She was only here for a matter of about a year or so.
Okay. He's not a British citizen though.
No, he's not a British citizen, and he's supplied, a declaratory declaration in support of her position, and with in association with the motion to vacate the temporary injunction. So again, he's not my client. I can't speak for him, but I'm sure he will be testifying in this matter. But I'm also imagining that whenever this goes to trial, that my client is going to be testifying from England. I don't know that.
And let me say this, that I have no problem with your client testifying from England, even if, let's say, somehow the coronavirus is somehow that whole pandemic is dealt with. Even if I don't have any problem with her testifying from England, I am going to have a problem with, unless we're still in status red, him testifying from England. I want him to come to the United States because this is his responsibility. She may be an innocent victim here. I don't believe that, but that is a possibility. So I have no problem with her testifying. Personally, of course, Mr. Capua may have, and other counsel may have other opinions, and they can raise those. I do have a significant issue with him testifying. I will probably not allow him to testify via Zoom, so he will need to be here if he wants to testify. Unless he can't get here.
I'll probably have an issue with that, Your Honor.
I just want to let you. I know if he can, and if it's possible for him to get here, because I'm not taking into account the COVID situation, but assuming that he can get here and that the COVID situation isn't preventing him from traveling here, I'm probably not going to allow him to testify virtually. But if it is the only way, if everyone else has to testify virtually, he can testify virtually.
We'll cross that bridge when we come.
We'll cross that bridge. I just want to make it clear. I want him to get here if at all possible. He needs to. This is entirely his responsibility. All of this, and the way he's dealt with this. He has an $18 million judgment against him. He has fled the country. He's told us he's not going to participate in any of these proceedings. This is all him. So I apologize if it truly is a situation where your client's the innocent victim here. I feel bad, but
I think
don't believe that.
She is really kind of a wholly innocent. She's very young. She is. I have stressed that she is autistic, which means she operates very internally. I have had an autistic nephew, and she has this gift of making these videos, which is sort of the center of her life. She's a charming, intelligent woman. I don't know how she'll bear up under cross-examination. I find her open, intelligent, and entirely credible. And also, you say, well, why shouldn't she suspect him? She's not autistic people don't think in the linear way that you and I think. You and I, of course, we're lawyers. We've been around. We always have a suspicion something is going on here. She doesn't. She just really doesn't. But you know, that's a bridge that's going to get crossed at some later time. But my question for today is, are you vacating these orders or not?
No, I'm not going to vacate unless Mr. Capua wants me to vacate. The one concern I do share with you, Mr. DeBose, is there were a lot of orders that were entered in this case. Some of them I found I didn't really like all of the terminology in them, and so I did vacate some of them. But if Mr. Capua, who is a very able counsel, who I've always known to be very forthright, feels like he can defend these on appeal, it's his call. So I'm gonna, but if there's anything you want to have vacated, Mr. Capua, to improve your chances on appeal, then I'm happy to vacate it. But it sounds like you don't want, and it's not going to hurt my feelings if you do want to vacate anything, Mr. Capua.
Your Honor, at this time, our position is we would request that the court not vacate any orders. I believe I can defend them on appeal.
And the other thing I want to say is that I really do want to get this thing tried in October. So, because if Ms. Bone really is an innocent party, I want to get this case over with so that we can stop this, this turnover. And so we need to make it. I've been saying this for quite a while. We need to make a determination who owns this. Is it what was represented in independent documents before the fraud judgment, or is it really Ms. Bone? And if Ms. Bone is the innocent owner, we need to get her funds back. And so I don't know. Obviously, I question that, but we need to get this case to trial. So I'm going to instruct Google, you need to cooperate with Discovery. Are you saying Google's not cooperating with Discovery, Mr. DeBose?
They've always said, when I asked them, are you going to be subject to Discovery in this case? And they have told me no.
Ms. Newsom, why aren't you subject to Discovery in this case?
Your Honor, I'm not sure what Mr. DeBose, what communication or who he spoke with, but we have absolutely been cooperative with the subpoenas that have been served. We have supplemented our productions, and we have not received any complaints or any thing that says we haven't produced something. We're more than willing to supplement and do what we need to do. So this is the first time I'm hearing about us not cooperating in Discovery.
Mr. DeBose, maybe
No,
go ahead, Mr. Kaplan.
So, may I make some comments on that? All right, so here's my issue with Google. Google claims it's a non-party to this case, but I sent some law to Google claiming that it is a party due to the garnishment proceeding. That's number one. Number two, I sent Google a request for production of documents a while back, and their position was that California, where the headquarters is at, does not want Google responding to requests for production because then it might make them appear as a party. And so then I went ahead and sent my request for production of documents out to Google's headquarters through a subpoena in California, and the attorney out there, the in-house counsel, they objected to every one. And I will say, Google has provided me with some documents, but as it relates to ownership, it's always been my opinion, Google, please send me 1099s. Please send me a 3 or 4 year history of money that has been monetized and who it has went to. And I haven't received those documents, Your Honor. And so that's been a little bit of my frustration. I've been trying to work with Mr. Hurst and his team, but I think if these documents could come to the table, that would assist the court greatly. Just as if I filed a motion to compel against Ms. Martin yesterday, because again, if she claims she's on these channels ever since she was 13 years old, which is 2012, show me some documents that you have owned the channel for the last 9 years. I haven't received the type of documents you would expect if you've been monetizing these channels, not for the last 2 years, because that's when we believe Brian Martin was involved in some sort of fraudulent transfer, but since 2012, and I haven't received those documents. And I think, again, if parties would be more forthcoming to produce these documents I'm talking about, it would assist the court greatly in making the correct decision as to who's the actual owner. So with all that said, Your Honor, if you could make an order from the bench ordering Google to produce these documents that I've been asking, or if I have to go through a whole motion to compel process, I'll do whatever the court wants. I'm just
I
trying
mean,
to.
ultimately, you'd have to go through a motion to compel process, but I'll just tell you, Ms. Newsom, I would order that to be produced. That's the critical issue in this case, is who really owns these channels, and tracking who got the money over time would be very, very helpful, especially if it was, for example, if it was Miss Bone the entire time getting the money, then that's strong evidence for Miss Bone. If it was Mr. Martin getting the money, and then when the fraud judgment occurred, it was Miss Bone, that would be strong evidence to the contrary. And so we need to get that discovery, but I'm not going to order it. I'm just going to tell you it would help us avoid a hearing. So
If I may, Your Honor, I just want to make a clarification here. We just received, and I'm looking at it right now, this was August, I think 3rd, a request for production to Google asking for these 1099s. And so this is my first time. This is our first time getting this in the proper form to Google. And so we are in the process right now in discussing that with the client and getting what we need to get. So I don't want it to be perceived by the court that we've been asked for these 1099s several times and we haven't complied. This is my first time seeing this.
sounds good, guys. Just get me an order on this motion to vacate, Mr. Capua, and let's try to get this ready for trial. We want to get this done hopefully in October. So go ahead and get that to me as soon as you can. And it's not going to be an excuse to not go to trial if you don't have this stuff. I would think that both of you would want this, Mr. DuBose. So aggressively getting this from Google is key to this case. So, but I got to get to my next hearing. So we're going to let you go.
Thank you so much, Your Honor. You have a great day and a weekend.
Thank you, Your Honor.
Thank you. All right, who's here for the last hearing?
Good morning, Your Honor. Dan Byer, on behalf of the plaintiff.
Who's here for the defendant?
Your Honor, this is a little bit of an unusual scenario. I don't believe anybody is going to be appearing for the defendant. We're in the background of this case, Your Honor, is that this stems out of an unpaid promissory note that results in a settlement agreement between my client and the defendants. The settlement agreement required certain payments to be made over time. Those payments weren't made. And the settlement agreement was specifically designed to expedite, because of the nature of the debt and the fact that the defendants would have no actual defenses to that. We expedited this process where in the settlement agreement, we provided for a process by which the plaintiff could just immediately file an agreed judgment.
I read everything, just so you know, and I'm going to go ahead and sign the proposed agreed judgment that you submitted, and we'll go from there. How does that sound?
That's exactly right, Your Honor. Though we appreciate your time and thank you.
Rhonda, if you could go ahead and print out in this cause number DC 218315, the proposed agreed judgment that was filed on 8/6/2021. Just that proposed agreed judgment. Can you do that, Rhonda? She got it. Okay. That's it for this morning, guys. So